to you contained in them for webcasting and training purposes and for the purpose of keeping historical records and making those records available to the public. Further detail on the DPA privacy policy can be found on our website. First of all, thanks to Stuart for facilitating today's meeting. He will be hiding in the background today and will step in if there are any technical issues that anyone might experience as we go through today. Hopefully there won't be any, but it's nice and reassuring to have him there. So this appeal is by Edinburgh Marina Holdings Limited against the City of Edinburgh Council's decision to refuse its application under Section 42 of the Town and Country Planning Scotland Act 1997, seeking to implement planning permission previously granted on appeal, and that reference was PPA-230-2458-1, without complying with conditions 1A and 1B of that permission. And in short, those conditions require the submission of reserved matters and the commencement of the development by 20th June 2023. In its application, the appellant was seeking to extend this period by 3 years to 20th June 2026. But given the passage of time since the application was submitted, the parties are now suggesting that this period is extended to 20th June 2028. The appeal was previously considered by one of my colleagues, and a decision dismissing it was issued on 13th June 2024. However, this was appealed to the Court of Session and was subsequently quashed. The matter was then remitted back to the Scottish Ministers for redetermination, and I have been appointed by the Scottish Ministers to undertake that redetermination. This hearing is the first of 3 sessions taking place today and tomorrow. This session focuses on flood risk and coastal protection. The second session will focus on progress on the site since June 2024, the contract with the development funders and the development project plan, and compliance with and delivery of the master plan. The third session will cover conditions and the need for contributions and how these should be secured if I am minded to grant the appeal. Agendas for all sessions have been issued separately to all parties. For the benefit of the live broadcast, and I know we've got names and rooms on our screen, it would be helpful if the lead participant for each party can introduce yourselves and identify or introduce those participating on your behalf. So if I start with the appellant first.
I'm Charles Price. I'm the managing partner of PIP Asset Management. We're the asset managers for the owners for the appellant.
I'm Steve McGavin. I'm representing the appellant. I work for WSP and we've been providing planning and development advice to the appellant.
Thank you.
I'm Katie Pearson. I'm a senior planner with WSP and I've been assisting Steve.
I'm Ian Struthers, an associate director at EnviroCentre, and we've assisted on the flood risk assessment.
Martin Nichols, also associate director at EnviroCentre, supporting with flood risk.
In the London boardroom, we have Martin Williams and Steve Shakespeare. We're directors with Arrow Global, who are the funding partners of EML.
Gary Freckleton, a partner at PIP Asset Management.
Okay, is that everyone for the appellant? Also down Vi Swanson, is she attending today at all?
Yes, hello, I'm taking notes on behalf of the appellant.
Okay, no, that's absolutely fine. I just make sure I hadn't missed anyone. Perfect.
Thanks.
Okay, well, thank you. Is there one person who will be leading the appellant's evidence today, or are you all just going to chip in, or you've got specific questions allocated to specific people? It's just so I can make sure I'm looking at the right people on the screen.
We have people allocated for each of the specific questions, but I suspect it will be colleagues from EnviroCentre that will be dealing with a lot of the questions today, but we'll all be chipping in.
Okay, that's perfect. Thank you. Okay, can I go to the council now?
Good morning, ma'am. Graham Nelson, solicitor for the council. And we have Sorry, let's see how we've got in the room. Thomas Finlay, close to Glasses, is our consultant engineer. We'll be speaking on flooding matters. Then we've got Gordon Comish next to him, who's transport manager and flood management. Then to my left is Leslie Carris, planning team manager. Then next to her is Christopher Sillick, planning officer, and Kenny Bowes, senior planner.
Mr. Nelson also had down Elaine Watson and Naomi Sandilands. Are they attending today, or?
They'll be here for hearing session 3,
Okay.
not the session.
Perfect. Again, just didn't want to miss anyone out of that. And for SEPA.
Good morning, ma'am. My name is Cameron Gregg. I'm a legal director at Morton Fraser McRoberts, and I'm appearing today on behalf of SEPA. I'm joined in our Edinburgh office by my colleague Isabel Salveson, and also with 4 representatives from SEPA who are separately appearing on the call, albeit they're in the room with me and we'll be sharing the room audio system. We have Mr. Alan Farquhar, manager, water and planning function. We have Mr. Steve McFarland, lead specialist, coastal flooding. We have Mr. Michael Spalding, senior specialist scientist. And we have Ms. Georgia Barbara, senior planning officer.
Great, thank you. And Mr. Gregg, will you be leading your team?
Yes, if you're able to direct questions to me in the first instance, I can turn to the appropriate specialist here.
Okay, thank you. And Mr. Nelson, I should have asked for the council. Will you be leading the council's commentary by allocating the questions? If I direct the questions to you?
You can certainly direct the questions to me and I'll allocate them out. Thank you.
Okay, thank you. And finally, Mr. Gibbons, do you want to introduce yourself to everyone on the hearing today?
Good morning, ma'am. My name is Lester Gibbons. I'm an owner and resident here at Granton Harbour, and I have been since 2013.
Thank you. So just some housekeeping before we start. When you're not speaking, if you can maybe make sure your microphone is muted, just in case any background noise or any feedback. There doesn't seem to be any issues at this point in time, but sometimes there can be a little bit of feedback. Phones and other devices should not be audible during the session, although I recognise that if you're not in the same room as people in your team, you may want to contact each other as the hearing goes on, which is absolutely fine. Just make sure your phone's on silent when you do that. If any team that are not all together does want a short adjournment at any point, then please let me know and we can do that. If there's any point you want to discuss as a team, then happy to do that and facilitate that. We will in any event have a short break during the course of the morning. And if we haven't concluded by lunchtime, we'll break for lunch between 12:30 and 1, just a convenient break point in the evidence. So the format of today, for those who maybe haven't taken part in a hearing session, is a structured discussion between us all, chaired and guided by me. The purpose of the hearing is to allow those taking part to put forward their views, and at the same time to allow me to obtain the information I need to determine the appeal. The discussion should focus on the issues that I've identified in the agenda, although there may be follow-up questions and parties may pose questions through me that other parties may need to answer. Please remember that I am taking notes. It is recorded, but it's helpful for me to take notes as I'm thinking. So please speak slowly and just one at a time. So before we move on to the substantive part of the hearing, are there any procedural matters that any party wants to raise, or are there any questions? So if I come to the appellant first, any questions or procedural matters you'd like to raise at this point? Lots of shaking heads, so I'm thinking no for the appellant.
Madam, just one issue that for the attendance of the fund manager from Arrow, he's available at 2 p.m. today. I think you've been notified of that, and he's available just at 2 o'clock. So if it runs on, we may have to deal with him and allow him to attend, because he can't attend tomorrow.
Okay, no, that's fine. I'm not anticipating that session 2 would run in tomorrow anyway, even if we go on a bit after lunchtime. But I'm aware he's only available this afternoon, so I'll make sure that we can cover that.
Thank you.
But thank you for the reminder. But yeah, I'll definitely make sure we get onto that today. Mr. Nelson, for the council, do you have any procedural matters?
Nothing to raise at this point, ma'am.
Okay. Mr. Gregg for SEPA?
Nothing to raise, ma'am.
And Mr. Gibbons, I'm not sure Mr. Gibbons is actually on the call just now, or if he's dropped out. Mr. Gibbons, did you have connection issues there?
Yes, I did. Apologies.
No, that's absolutely fine. Did you hear me outlining the format of today?
I didn't, but I got your agenda if it's of a similar lines.
Okay, I'll just go back and explain that. So I was just saying that it's a structured discussion between all of us, which I chair and guide us through. And the purpose is to allow everyone taking part to put forward their views, and at the same time to allow me to obtain the information I need to determine the appeal. Obviously, the discussion should focus around the agenda points. If you've got questions, you can ask them through me. And as I was saying, that although this session is recorded, I do take notes as we go through because it helps me obviously think and take it in as we're going through it all. So I'm just saying if people can speak slowly, you'll see me noting away and just one at a time, but I will give everyone a chance to speak. I was just asking, do you have any questions at this point in time or any procedural matters you want to raise? Any queries that we can discuss at this point?
No, thank you, and thanks for going over that again. Thank you.
That's absolutely fine. So I just thought it might be useful before we launch into the questions if I go around the parties and if you can make me aware of any documents that you're likely to refer to, just so I can get them on screen. I've got stuff on screen already, but it might be useful if I can pull them up just now, and for other parties to make sure they've got documents available too. That doesn't preclude any party if you're going to a document that you haven't raised at this point in time. So anything that's on the case file that's been submitted, you can refer to in the course of the hearing. But it might just be useful if we've got documents handy for all of us. So can I ask the appellant, do you think there's any documents you're likely to refer to that you think I should get to hand?
Ian, is there anything you want to specifically refer to?
I think other than the documents referred to in the agenda, which is the 2024 FRA and the SEPA pre-application responses that are referenced.
Okay, that's perfect. I've got all those already. I anticipated you might want to refer to those. Mr. Nelson for the council, is there anything else you want to raise at this point?
I think it's similar, ma'am. I think most of it will be you've got our submissions, and I don't think documents-wise it's much more beyond what's been stated there.
Okay, great. Mr. Gregg for SEPA.
Similar, ma'am. We might want to, depending on how the discussion goes, turn up the position statement from SEPA, which I think everyone has to hand, document 40 in the authorities bundle. We might also look at the previous reporters' decisions relevant to the site, your predecessor in this case, and perhaps the decision in connection with plot 35A. But I'd suggest that we perhaps see how the discussion goes and turn those up if required.
Okay, that's great. And Mr. Gibbons, I've got to hand the documents you've submitted and your correspondence recently, so I've got all that to hand in case you want to refer to those, the information on force ports and your emails. Is there anything else you think you might want to refer to?
Not at the moment, thank you.
But as I say, that doesn't preclude anyone from asking me to look at any other document. They're all in the case file, so they're all evidence before me. So don't feel I'm excluding any of those because they are all relevant and you can refer to them as you need to. Okay, so if we just start with questioning, we'll work our way through the agenda. Depending on the discussion, sometimes we find we drift into other questions, and that's absolutely fine. There may be a bit of overlap, That's always the case when you're putting the agenda together. You're trying to identify the items you want information on, but sometimes they can kind of overlap and stray into one another. But that's absolutely fine. I will take stock as we go through, and particularly at the end, to make sure that we've covered everything and that I've got all the information that I think I need. So if everyone is okay, we will go on to the first question. And this was, there was quite a lot of, I suppose, conflicting evidence as to what the flood risk assessment 2024 did, how it responded to SEPA's comments, whether it addressed them or didn't address them. And I was trying to kind of narrow down that and focus on really what issues have been resolved, what the key issues are still that are outstanding, and what the implications of those are. So really, if I can maybe come to the appellant first, and it was just really to get, a summary of how you think the flood risk assessment of November 2024, so FRA 2024, how that responds to SEPA's and the Council's concerns raised in their consultation responses. And then maybe you could comment whether you think any concerns remain, and if so, how those concerns can be addressed. And then I'll go around the other parties for their views too. So can I come to the appellant first?
Sure. I will try and keep it brief. That's what I've tried to do on my notes. So the 2024 FRA, aimed to respond to all the concerns raised by SEPA prior to its issue, which was in November 2024. The latest holding objection reference to that point was SEPA's holding objection of the 15th of August 2024. We're not aware of Edinburgh Council having concerns beyond those expressed by SEPA. So the 2024 FRA, what it specifically reports on revised spectral wave modelling that was undertaken by DHI for plots 26 and 35A. And this additional wave modelling was undertaken to address SEPA's requirements to account for sea level rise due to climate change in wave transformation modelling, to account for the impact of climate change upon increasing wave heights and wind speeds, and lastly, to consider an undefended scenario by removal of the existing eastern and western breakwaters in modelling. The updated analysis was then used in our FRA report to infer extreme wave crest levels for all coastal interface plots within the master plan. SEPA's response also required that overtopping modelling be undertaken, which DHI also undertook for the master plan site. So that the report was issued in November 2024. Subsequent to that, SEPA have issued a further response with a holding objection on the 22nd of May 2025, which coincides with the procedural notice for this hearing. And that holding objection raises further requirements to be addressed, specifically further confirmatory analysis relating to climate change representation and wave modelling, as well as further inundation modelling. The appellant has commissioned DHI to undertake these works to address SEPA's requirements, but given the timescales, that work is still in process.
Can I just clarify what this response was of 22nd May 2025 from SEPA?
It's a long one. I'm not sure what you're wanting me to describe. A blow by blow, or
was that a response to this appeal or to a different application? Mr. Gregg, you're shaking your head. Maybe you can just clarify for me.
Yeah, I think that the response is specifically in relation to plot 35A, but references the November 2024 FRA. So yeah, there is a bit of I guess overlap in that.
If I might assist you, Madam, this is a concern that we note because the appeal is in respect of a extension of time for outline planning permission in principle, and the consultation provided by SEPA seems to be a complete photocopy of the consultation responses on the separate full application of Block 35A. We fail to understand why the consultation for an individual site would have any particular relevance to the Section 42 application for a time extension. Also, and I'm not a technical expert, but having read the conclusions, it says that even on an undefended scenario, what does that mean? You're to imagine that these substantial rock breakwaters and sea defences are not there, a hypothetical proposition. And in fact, that was done and showed that there was no flood risk. SEPA then responded, stating that they still wanted their holding objection because they wanted further information. Now, I just make the point, this is for 35A. We then asked them under 35A before commissioning the work. Our consultants repeatedly asked SEPA to supply the details of the information that we were required to provide. There were several requests. We never got the details until the 22nd of May of this year, which is the same date that you notified us that you wanted a hearing. The moment that we got the details, we were then able to commission the works. They're not cheap, come to over £50,000. So there was no point in starting the calculations if you don't know what you're calculating. And I am advised that the information and the conclusions are subject to Ian commenting and Martin commenting, but I think we should be about 3 or 4 weeks away from being able to supply all the information that has been requested in detail by SEPA. And it looks like everything is in order. I don't think this actually concerns, it's my personal view, the Section 42 appeal for time extension for planning permission in principle master plan. It's relevant to 35A, but it seems to have been adopted by CEC in respect to this appeal, which I don't think is relevant. Thank you.
Okay, before I open up, my understanding was the FRA 2024, let's call it that, was submitted, yes, with plot 35A, but it was submitted as a site-wide flood risk assessment for the Section 42, which is why it's relevant. Because I have to determine the Section 42 in accordance with the development plan, because it does, if I grant it, it would be a new plan permission. So therefore, you kind of go through the same test as you would for a normal planning permission or planning application, albeit that what you're looking for is a change to the time. You've still got to go through that process of assessing it against development plan, which is why this has come up as a relevant issue. So my understanding was the flood risk assessment, yes, primarily for plot 35A, but it was widened out to cover the site and in particular to address the issues that were raised by SEPA previously. And it was highlighted to me in the appellant's response to the procedure notice way back in April that this new modelling work had been done, wave modelling work had been done, and that had been fed into the new site-wide FRA, which is what I've got, the 2024 FRA. So I suppose now we're thinking, well, is this now going to be superseded by another bit of work, and is that more relevant to plot 35A? And is the appellant happy that I determine the appeal based on what I have and the correspondence to date, and make my determination based on the views I get today on whether or not that deals with the concerns that SEPA had? And the last response I've got from SEPA in relation to the FRA is the 20th of February, which at that point they were saying they maintained their holding objection, and there was a kind of two issues raised at that point and summarised there. One was the methodology used to consider a suitably precautionary approach, and the other was demonstration that safe access and egress can be achieved. So that seemed to be that point at 20th of February, the two outstanding issues. And really I was trying to get the point as to whether the appellant thinks that those have been addressed in what I have, which is the November 2024, or are there still concerns? And if there are concerns, how should they be addressed? So I'll ask the appellant if there's anything else you want to add before I maybe move on to SEPA to get their take on this. I suppose, Mr. Price, do you understand?
Yes, I do.
Why I think it's relevant, or why
I can see why. The site-wide FRA was originally requested by SEPA in May 2023. Is that right, Ian? In relation to the Section 42 application, we agree with you, Madam, that there isn't a clear basis for a site-wide FRA in relation to a Section 42 application, but nonetheless, this was progress by the appellant in good faith, with reporting also incorporating 2024 updates, as Ian has just confirmed. But the specifics that we're now talking about seem to apply specifically to plot 35A. And that's really the issue. It would appear that there would be no risk or concern in granting this appeal based upon the information that is before you. And the holding objection that continues with SEPA, it could be dealt with simply by a condition that the information is supplied and must be satisfactory to their, quote, says in the Act, reasonable, close quotes, requirements. I mean, that would solve the issue. I mean, the appellant wants to cooperate in every way possible, but there have been interminable delays here just to get basic answers. Once we've got the details, we've got on with the work. Hope that helps you.
Okay, no, thank you. I mean, just to clarify, I'm not saying this flood risk assessment is not relevant. I'm saying that I need to determine it in accordance with the policies, and there are flood risk policies. So, okay, I'll go on to Mr. Gregg for you to come back with SEPA's take on this.
Thank you, ma'am. Obviously quite a lot in that discussion there, and touches on some of the later agenda items as well. But SEPA's view is that a site-wide flood risk assessment is appropriate and required in order to assess matters for the purposes of this determining this application, and also that this is an in-principle significant matter which requires to be addressed at this stage, rather than by way of condition, kicking the can down the road. But to hone in on the item under consideration just now, and SEPA's view on how the 2024 report responds to their concerns, I propose to pass over to Mr. Spalding in the first instance, and also Mr. McFarland, who will be able to give you more detail on SEPA's position. Mr. Spalding.
Thank you, ma'am. So I think, firstly, it might be beneficial for all on the call if I just very quickly sort of reiterate what the SEPA position is for the Granton Harbour. It's already been mentioned previously, but we've consistently submitted holding objections to the master plan area post MPF4 implementation, and that's consistently been to request further technical information. This isn't a case of us, saying that we know the site's a coastal flood risk and there's nothing that can be done, and we therefore object to principle. It isn't that. obviously with the implementation of NPF4 policy 22, that enacted more stringent requirements in order to take climate change into consideration.
I actually interrupt you there, sorry. Is anyone having difficulty hearing? Because I'm getting quite a lot of feedback from your microphone when you speak.
If you just move it a bit closer. Or is that any better?
Yeah, that's a lot better.
Oh, perfect. Sorry, it was just a wee bit too far away from me.
Oh, that's perfect.
So yeah, sorry. Obviously, NPF4 sort of mandates now that the flood risk area that has to be avoided is the 1 in 200 year event with a sort of satisfactory uplift for climate change as well. But we also acknowledge that there are 4 exception criteria of policy 22 that can permit development within a flood risk area. So in this instance for the master plan, the exception 4, which is redevelopment of a previously used site, which has been identified as there been a need to bring back into positive use, and that's earmarked in the local development plan. We do acknowledge that the City of Edinburgh Council have, they've confirmed that the site is an exception 4, so we fully accept that means that any development proposal there could, in theory, be located in an area of flood risk. But on the other hand, those exception criteria, they also then have to meet a list of sort of supplementary bullet points within policy 22. And this is fundamentally where we currently have our concerns that remain with the latest iteration of the flood risk assessment, because we don't believe that at this point that provides all of the necessary evidence in order to confirm those bullet points. And then we also have sort of, some outstanding concerns as well in terms of the key aspects that haven't yet been considered. And for those points, I'll pass on to my colleague Steve McFarland in a bit. But in terms of those bullet points, the first of which is that the risk of flooding has to be generally understood, and at present we've still not been able to agree upon what the design flood level is between the parties. And then in particular for exception 4 cases where flood risk has been actively managed at the site as opposed to avoided, those exception 4 criteria have to evidence that no potential plots within the master plan area could become an island of development, and also it has to evidence that safe access egress is feasible from the wider master plan site. So in order to verify that those bullet points can actually be met, we have to have an assessment and an awareness of where the overtopped water from the coast onto the site may propagate across the site. We need to know, is it going to pool in specific areas, or will it just flow straight back out to sea, or will the topography of the site sort of allow for wider inundation? And at present, the latest iteration of the FRA doesn't yet contain a full analysis of those aspects, and that's why we then requested specific site-wide overtopping and inundation assessments in our previous response. And we do maintain that view. We appreciate some overtopping assessment has been carried out, but that at this point focuses more in terms of overtopping potential risk of damage to buildings as opposed to full inundation. So it's essentially to say that the 2024 FRA, based on the information within that, at present we're not yet able to determine if access egress is fundamentally going to be an issue, or whether some areas of the development might result in some plots becoming an island of development. And that really is our outstanding primary concern, and that's the reason for the holding objections that have been submitted most recently. So I think it is important to reiterate that it's not that we're saying the site is categorically undevelopable. It's just that we don't yet have enough information in the FRA to determine what the level of flood risk is for the site, and if all of those relevant bullet points in policy 22 could be met. I think it's also probably appropriate to acknowledge that even if that further analysis was conducted and it showed that the access and egress is in fact an issue, because it's an exception for a site, there are, we potentially could accept mitigation options to remove those issues if they were identified. So I think there are potential, avenues forward, but we just fundamentally need that sort of assessment of where the overtopped water will go. And maybe in terms of the kind of more technical aspects, I'll maybe pass over to my colleague Steve McFarland, who can kind of go into a bit more detail on that.
Thank you. Just checking you can hear me okay. Yes. Yep. Okay. Thank you.
Thank you.
Okay, so just wanted to add a little bit more on what Mr. Spalding said there. And first of all, just acknowledge, that there has indeed been a lot of work done by the appellant on flood risk, and EnviroCentre have been amongst the people doing that. And we are, quite a long way further on than where we were. I note that more work has been commissioned. I wasn't aware of that, so my comments are based on the referred to November 24 EnviroCentre report. And I'm just going to take you through 2 or 3 things that I'm still not comfortable within that report. And I appreciate some of those may be addressed by the further work you mentioned, but I think it's important to explain what those are. So just starting with our general approach to these things, it's we do try and follow the source pathway receptor type assessment, where identify where the source of the potential flooding is coming from, how that water moves from where it is into where it can impact on things, and then the receptors themselves, whether that's already developed plots that are proposed, or the infrastructure that connects some of the roads and so on. So that's our sort of basic approach to this. And our first step.
Can I stop right there? Mr. Freckleton's got a hand up. Is this a question relevant at this point in time that you want to come in on?
Sorry, I was just putting my hand up. I wanted to respond to something once Steve has had the opportunity to finish.
That's absolutely fine.
Okay, thank you. I'll carry on. So the first thing we look for is the extreme water levels, and just to put that into context, we're looking at the likelihood of flooding in a 0.5% AEP, or 1 in 200, with the climate change allowance for sea level rise added on there, and that's become a requirement, I believe, of the National Planning Framework. We have a national data set, which is called the Coastal Flood Boundary data set for these extreme sea levels, and that's based on recorded data from tide gauges around the UK, including one in Leith. EnviroCentre in their report have correctly identified the extreme sea level with climate change sea level rise as, I believe, 4.83 metres above ordnance datum. And so the first point I would make is we wouldn't really expect to see any levels below that in being put forward. So moving on to Granton itself, it's a large site. It's exposed on 3 sides to the sort of open sea or open estuary. And so we do take a little bit more care then in trying to understand what the impact of waves in association with those sea levels are. And we do fully accept that you don't get the biggest waves on the biggest sea level. So, a little bit more subtle approach is required, so we're not, over estimating what the flood level is. So DHI, Danish Hydraulic Institute, I believe, were commissioned then to do a joint probability analysis to come up with those pairs, which they've done. And we have had, I think, I can't remember exactly when, probably a year, 2 years ago, we had a sort of a discussion with them on their work, and we resolved that approach was fine. We're happy with the way they were doing it. What we did have were just some queries outstanding about how that joint probability approach was applied to the site and in the determination of the flood levels. So if I could just summarise how I think that's gone. So in order to get to the new flood levels, a kind of an approximation was applied, whereby for each of the occurrences of still water level and waves that added up to that probability of flooding, the water level was taken and added to half of the significant wave height. And I'm just going to, if I may, just read out the section 4.5 in the latest report, which says, based on the undefended scenario modelling undertaken by DHI, the estimated extreme significant wave height crest level for Granton Harbour varies between 4.73 and 5.1 at different locations along the coastal interface. And that's where my first point where I'm quite uncomfortable about. I'm not really comfortable with levels being quoted for the site-wide that are less than the still water level alone. The minimum water level will be the CFB still water level. What drives that water level is generally storms in the North Atlantic and into the North Sea and so on, and you would expect there to be winds, etc., to be associated with that. So we'd also be expecting, there would be at least some wave action there. So the 4.83 really would be the minimum level we'd expect to see. And I think although this technique is used as an approximation and is appropriate in many cases, and we can live with it in many cases, I just think for this site, and because of the results that it gives, remain uncomfortable that it's adequate as a precautionary approach. That's my first sort of outstanding issue I have. So moving on to the second one, if I may, going back to that source pathway receptor approach, kind of need to understand how waves and the water that comes from the waves that overtop the fringe of the development, how that moves around. And I think this is a fairly sort of straightforward ask, because we can't tell from the information that's provided whether the water that comes over the structures, whether it remains in an area that doesn't cause impact and makes its way back out to sea, to safety, whether it flows, inland into some of the lower parts, and could accumulate there and cause. So we don't know where that water goes, and in order to be able to make that assessment, kind of need to know where that overtopped water goes. So we absolutely acknowledge that overtopping has been done. It's been applied in terms of safety for pedestrians and buildings and so on. I don't disagree that it's, that's an appropriate thing to do. But what we're missing is where that water goes, and just to reassure ourselves that it isn't affecting existing sites, new development sites, or the infrastructure, roads and so on. That's my second point. I think third and final point, I think certainly for now, is within the overtopping assessment that's presented in the latest EnviroCentre report. In 4.5, that's presented as an undefended scenario, but within the text it acknowledges that includes the consented breakwater to a height of 6 metres. So contend that it's not really a true undefended scenario. And we can see that the overtopping that's resulting from that is certainly lower than some of the earlier assessments, despite the additional wave modelling to address the undefended scenario. So we kind of like to see what the fully undefended scenario would be like, and we'd like to know that in that case, water can be safely channeled from the site back out to sea without impacting on any of the receptors that I've previously mentioned. So, so thanks. I have nothing else to to add to that at the moment. I hope that was clear.
No, it's really helpful. Thank you.
That's unless there's anything else we can assist with, ma'am. That's a summary of the SEPA concerns that still exist.
Okay, that's really helpful. Before I go to Mr. Freckleton, can I ask the council if you've got anything to add to that, or if you're really kind of relying on SEPA's position in relation to this matter?
Thanks, ma'am. I'll let my colleagues add to that in a minute. But it was just to clarify on the 22nd of May letter that you were looking for from SEPA, that's lodged as document CEC 63. So it should be there before you.
Okay, I'll double check that.
Thanks. I'll pass over to Thomas, introduce earlier, to speak on this issue.
Yeah, I'll probably keep this quite brief because I think we do echo the comments already raised by SEPA, so I won't cover them again. One point that is additional is we require an independent consultant to check all major applications, and that's something we would request. And as part of that, say, declaration certificate that should be provided with all applications that we need. We'd also ask the applicant to confirm the height, the crest level of this proposed new revetment and wave wall. So I think the original consent for the revetment says it's a crest level of 5 metres above datum, whereas the November FOA assumes it's 6 metres. So just a bit of clarity on that point. And the SEPA highlighted the FOA is reliant on this proposed revetment. So we want, it'd be good to see an undefended scenario, but also we'd want to see confirmation of who is going to adopt and maintain that structure. We'd also ask for a post-development overland flow path drawing. So that's typically used to confirm how surface water runoff will flow through the site. That overland flow path diagram could also be useful to confirm how overtopping volumes will be managed on site. So that's something we'd request as well. But equally, the applicant may choose to conduct more detailed overtopping modelling to confirm how those volumes will accumulate and pond on the site and throughout the master plan. And I think, there was some, maybe clarify later about, I know in the past there's been discussions about the significant wave height and whether the maximum wave height should be considered. So typically, overtopping calculations considers two conditions. One which will consider the average discharge over the defences, and then the second would be, the maximum discharge volume. So we're happy that the applicant has done assess the average overtopping, but not necessarily the maximum discharge volume, which we typically use the maximum wave height. I think, there are our points.
Okay, thank you for that. Mr. Freckleton, did you want to come in?
Yes, thank you, ma'am. I just thought it might be helpful when I was listening to Cameron discussing or raising the fact that they're looking for the site-wide overtopping, given that the regulations and MPF4, etc., have moved on since the previous permission was granted. But I thought it was worth just pointing out, in case people maybe aren't aware, that on a site-wide basis, all of the infrastructure has already been constructed. So the roads, pavements, cycleways have all been built at the level previously approved. It's around 6 metres for most of the new roads, OD. So the only part of the roads, pavement, cycleway infrastructure not yet constructed would be at plot 35A, and that's one of the reasons why we've obviously focused on the overtopping, etc., at that plot. So I'm not sure how that would, in practical terms, work. All the streets are already built because we had the permission, or Forth Ports had the permission in the past. I could maybe be helpful to pick up on Steve's point, Steve McFarlane's point about the Inner Harbour revetment being included in the undefended scenario. Obviously, the undefended scenario involved removing completely the eastern breakwater and also the north mole, etc. So these are the projecting existing features of projecting rock. The fact that we do have an edge that is simply the existing reclaimed ground has an edge condition. It's not a projecting breakwater, so it's not a sea defence necessarily, but at some point the land has to go into the sea. So I'm not sure exactly what the technical, I'm not sure how technically we would show that is not existing, how the land meets the sea without any sloping revetment at that point at 35A. And just finally, there was a question from CEC regarding the query about the height for the new revetment between 5 and 6 metres, and just to confirm that because it has a concrete upstand and a bird ledge and a solid concrete upstand supporting a proposed handrail, it would be minimum 6 metres as per the most recent modelling, just to tie in with the existing levels of roads, pavements, cycleways, etc.
Mr. Gregg.
Thank you, ma'am. I don't know if it would be helpful for us to come back on some of the points there raised by Mr. Frechton.
Yes, we can come back on those points.
In relation to I do appreciate that there's existing development which is previously consented and built out and existing infrastructure. We're obviously in a different policy context now with MPF4, and we're looking forward to whether or not this particular application should be granted consent, and that's the context in which the site-wide flood risk assessment is required. On the revetment point, I'll perhaps pass you over to Mr. McFarland, who might be able to provide some clarity on SEPA's position there.
Thank you, Mr. Freckleton. On the revetment point, yeah, absolutely, the land has to meet the sea at some point. I think what I was looking at there was the revetment is raised above the finished ground levels, which I know those haven't been established yet, but they, previously they're around the 5 metre mark, and the revetment was at 6 metres height, and I think there was also a proposal in there that it could be raised to 7 metres. So it would be that raised element of the revetment that would be removed for the undefended. I hope that clarifies that.
Yes, that I can now understand where you're coming from. I can confirm that the existing roads, pavement, cycleways, etc., are all around the 6.1 metres. So there was no proposal for the ground level of, say, plot 35A to be 5 metres. I'm not sure, there may have been an error at some point in the past, but that's not proposed. So yeah, it's all to tie in together, and the new revetment, while it might have an upstand for a handrail, the revetment itself is not to go up. It's not, say, a retaining structure or anything like that. Hopefully that clarifies.
Yeah, I think that clarifies from my perspective. Mr. McGowan, do you want to come in to respond to Stephen's points that have been made?
Yeah, it was really just thanks for that. It was really just to respond generally to Mr. Spalding and Mr. McFarland's points. I think it's positive. I think that I took it as being constructive, that they were, seeking to help and seeking clarification and seeking further information. And I suppose that's what we have tried to do all along. And just to reiterate as well that I think the final request for that additional information has only come in May. And as Mr. Price has already said, the appellant has commissioned a fairly extensive piece of work by DHI, which is obviously underway just now, but not yet complete. And we hope that, working alongside SEPA, that we can address all of these concerns.
Can I just clarify just on that? So the work that you're doing, are you fairly confident that it would address all the concerns that have been outlined today by Mr. McFarland?
Well, I wouldn't profess to be anywhere near a flood risk expert, but we have commissioned the experts to address that work. And I think, as I said, working alongside SEPA and I suppose hopefully, if SEPA can work with us and respond to requests in as timely a manner as we can, then hopefully we can address all of the points that have been raised today and indeed in the last lot of comments that SEPA put forward.
And is this bit of work for plot 35A, or does it look site-wide in the same way that the FRA 2024 does?
Madam, it must refer to 35A because that was the real subject of the matter, which has basically been conjoined or put into the section 42 for the reasons that you've stated. That's accepted. But I can give you a little update because, again, please, I am not an expert on flood overtopping and calculations, and I'm sure you would agree with me. But I have seen late yesterday some initial responses from DHI, which seem to confirm that there are no issues, that it satisfies everything that you've heard from SEPA, who quite correctly say, yeah, there's no reason why this site can't be developed, and we accept that they and CEC must take care to ensure that with no flood risk, and I can assure you that the development side don't want to take a flood risk either. But it is remarkable to bear in mind that a large part of the adjacent land has already been developed. And we took the trouble of looking through every single report to committee and consultation response. And there were no suggestions that the wider site, which had been developed, had a flood risk. And that's not to say that the world hasn't moved on, and we have to be careful and conscious of what's happening going forward, and to take all precautions that can be taken. And that's exactly the policy of the appellants. One of the reasons why they suggested that this inner harbour revetment wall would be constructed so that it could actually classify itself as a sea defence, because it represents one whole elevation to 35A, which covers a large amount of area, which leads on to other parts of the site. So it would be a very useful attribute, notwithstanding this curious but understandable request to I want an undefended scenario. I don't know how you would ever imagine that all these significant breakwaters, which are 6, 7, 8 meters wide and go down God knows how many meters, involving several 100,000 tons of rock, how it could ever be imagined that they would somehow be not there. But if that's what they want to do, well, we went, fine, jolly good, it will be done. And we did it. So I would just say that I haven't heard anything today that would suggest that there's any concerns. And I think that we'll be pleasantly surprised when the information is provided to SEPA, because it will answer exactly the points that they've raised. And therefore, we're very grateful for their input today at today's hearing, because we can rely upon that and say, well, that's what you said. This is what we've done. Now, will you please withdraw your holding objection on 35A? Obviously, in respect of the section 42, it's there, but you may take the view that everything else is in order, so it's not going to affect or prejudice the grant of this appeal. Which will expedite the development in the first place. Thank you.
Just come back on a couple of points. My understanding is that I don't think SEPA are saying the whole site is a flood risk, but that how the water runs into the rest of the site could cause consequential issues from a flood risk of the way we're talking. I kind of get that. Can I just clarify? You think this work can be done in the next 3 or 4 weeks? Is that what you said at the start of today?
It's nearing completion, is what I've been told. And then what happens is all the calculations, which take quite a long time and involve a lot of expensive computing time, that's I think was the way I would put it, have then got to be looked at. So it's not done by AI, it's done by Ian and his colleagues, and then they've got to meet and liaise. But the initial results that I've been made aware of in the last 24 hours would seem to answer the points raised by SEPA. In other words, these are all matters. Water running into the site, if it ever gets there, will have been dealt with. The overtopping analysis has been done on a calculation basis that they've finally detailed in May 22nd of this year, which has enabled us to do the work. So we really have to respond to what SEPA want, and that's what we're doing. You can take it as an informed view. I can't give you the total assurance, but I wouldn't be saying it if I wasn't confident in the fact that what I've seen to date, and I'm not an expert, I can only look at the conclusion page, but on the conclusion page, it looks like that there is a full answer to everything that I've heard today from SEPA, which appears to be reasonable and clarifies the position. We have been trying to consult with SEPA directly for nearly 3 years, 2.5 years actually. And so this is a useful opportunity to hear firsthand, and hopefully we can continue this dialogue outside of this forum to speed things up and make sure that they're happy with what they're receiving. I would ask that, and I would ask to hear from SEPA that be willing to do so, to meet Ian Struthers and DHI and their colleagues as necessary once this information is available, and to make sure that we've covered everything. Well, we've got nothing to hide. We want to do it properly. That's my instruction from the appellants, and that's the way we will deal with it.
Thank you, Mr. Struthers. Do you want to come in?
I was just going to come in on the back of Charles's comments. So DHI are progressing the further work stemming from the 22nd of May SEPA response. It broadly falls into two parts, and that was confirmatory modelling in relation to climate change, to essentially to repeat their spectral wave analysis with and without sea level rise, to demonstrate. It was basically based on the preliminary, based on earlier outcomes. SEPA's concern was whether the impact of climate change upon increasing wave heights is adequately reflected in that wave modelling. DHI have undertaken that confirmatory modelling, and based on a comparison with and without sea level rise, they are confident that those outcomes can be justified for their spectral wave modelling. The second part relates to the inundation analysis. I can't comment on that because I haven't seen any update on that. It's one of those things where we're kind of a party once removed. It's DHI doing the modelling, but that is in progress, and it's a matter of timescales for getting to the end of that process.
Okay, given that I didn't know this work was going on until obviously we started the hearing today, which is absolutely fine because I know things move on and processes change. I'm not suggesting that we adjourn or don't continue with hearings. I think we should do all the hearings. Do you think I should assist my determination of the appeal until I have this information?
I was going to just say, Madam, that I don't think that you would need to. I think that basically this is very specific to plot 35A, and you've heard that everything appears to be in order. It shouldn't prejudice the outcome of this appeal for what is basically a planning permission in principle. Because each time an application is brought forward to the council for an individual site that hasn't been developed, these issues would be addressed in detail. If they hadn't been addressed, they would have to be addressed. You'd have to have a new FRA. You could ask for yet a further site-wide FRA of circumstances. You can ask for all of these things. That's the local authority's normal processing way, and any applicant, any development applicant, would know that. So I think that one would be able, with to allow this appeal without any concerns about further information to come on individual sites, because there are individual sites where they're going to have to be the subject of new planning applications, whether they be AMC or not. 3031, for example, they are right on the edge. I mean, obviously, when the sites are further away from the edge, there may be less concern of the local authority. If it's adjoining a site that's already been built, they may say, no, it's all fine, we can rely upon what we've got. But as you get close to the edge, like on plot 26, which is owned by somebody else, or 3031, which is right on the edge, I would think that the local authority, well within their justification, would be fully justified to ask the information. But I don't see how that would interfere with this actual appeal. You should be in a position to say, look, it all looks fine. It is capable of being developed. There might be mitigation issues required, and for the individual sites, it's quite clear that this individual site owner, the appellant, is doing the job that it is being asked to do by SEPA and by the local authority, acting reasonably. That's what we're doing, and I therefore don't think you should assist it. I think it has gone on really long enough, and we'd like to somehow truncate the proceedings to get on with the development, as you'll hear later.
I suppose what from hearing from today, though, is that this would be a new plan permission over the big site, the whole site. And from what I'm hearing is there's been no analysis of how the water would run through that entire site if there was overtopping. And so my understanding is, for SEPA's position, not trying to put words into their mouth, is that taking that approach of individual flood risk assessments per plot doesn't then address that holistic view as to where the water is going to go and how it impacts on other parts of the development. And for that reason, my understanding is the council and SEPA don't think this should be conditioned to anticipate flood risk assessments coming through with your approval for matter specified in conditions, because at that point no one knows how the water would affect other developments, and I guess the policy framework's changed in that respect, and that is a consideration. So all I'm saying, maybe this was the wrong word to use, the target date for my decision, this appeal, bearing in mind these hearing sessions, I think is the 10th of October. So there is a time frame within that for this information to be submitted as new information and allow parties to comment on it. If it sounds to me like it's likely to be a material consideration, which I should have regard to, bearing in mind that the work's ongoing, not that it would necessarily delay my determination of the appeal, given that it's one aspect and there's other things I've got to think about. But it's whether parties think I should take account of this information when it is available, allowing other parties to comment on it to factor into my decision making. That's maybe this was the wrong way to use sorry about that, but whether you think that is appropriate, that I wouldn't issue a decision before I had a chance to look at that information and parties had a chance to comment on it.
Well, as I say, I don't think it actually impacts upon the new planning consent with a condition that has an extended time, because everybody's fully protected by the procedures that apply to individual sites, and therefore I don't think you would need to delay. Obviously it's finally your decision, but this work about water flowing into the site, I mean, 35A is 4.1 acres. It would have to be one massive overtopping above 6 meters or 6+ meters of sea walls. It would have to be some extraordinary circumstances, and so far, even on the extraordinary circumstances being modelled, we're not seeing anything. Remembering that before you get to the land, there is a harbour. There's a body of water, so the water comes over bits of wall or sea defences and plops into a harbour, which is going to be the marina, and how this marina is going to whip up waves in the marina itself to get onto the site. It's difficult to imagine. Yes, looking the other side to the Forth, looking to the other elevation, it is possible you could get some overtopping of the western side, but from the calculations that we've seen, it would look to be de minimis. From the other side, where the storms normally come, that's the eastern side, you've got another harbour in between you. You've got the Eastern Harbour, which is a large body of water, and then you've got an eastern breakwater, eastern sea wall. It would have to be something quite extraordinary for the water to overtop the eastern seawall and overtop the eastern breakwater, bounce off the eastern harbour, bounce over the western harbour, and come onto the land. I mean, that is quite an extraordinary feat, and I'm not sure you could even model it, but I don't think it would happen. So I think that it is right to be cautious about water coming into any site, and that the mitigation issues are there. But I think that is something which I think even SEPA have accepted. It can be dealt with, and will be dealt with. So for that reason, I would say don't wait, don't assist it. And who knows, you may very well find that the information is provided to SEPA before your decision making on October the 10th. Whether everybody will be able to respond in time, I've got no idea. But we'll certainly do our best, because it's something obviously that we want to get it out of the way. We don't want it to delay. So.
Okay, that I get your position. Mr. Gregg?
Thank you, ma'am. A couple of points coming back on what Mr. Price has had to say. First of all, on behalf of SEPA, I wouldn't accept any insinuation that SEPA have somehow been unclear or have failed to engage in this development. Quite to the contrary, SEPA have undertaken a huge amount of work and have been consistent in their requests, looking for a sufficiency of information to enable the flood risk assessment of the proposal to be assessed in accordance with the current policy landscape and in accordance with the relevant policies in National Planning Framework 4. On the back of that, second point, in order to properly assess this application, SEPA's position is that you do need this information. You need a flood risk assessment that addresses the points that have been consistently raised by SEPA. It's welcome news to hear that work's underway to provide that information, and I accept that it's also going to be relevant to the Plot 35A application, but in our submission it would be highly relevant to this application as well, and you need that information and you need SEPA's view on it in order to properly assess the flood risk at the site, in order to reach a determination. And there was some discussion there about, I think, some discussion about formal flood defences and the status of the breakwaters, etc. I think you have our position on that, and you know SEPA's position on formal flood defences and the informal flood defences and the respective roles they have in flood risk assessments.
We will come on to the flood risk defences later on the agenda, so I'm kind of not straying on to that just now. Can I get the council's view on this new information? Mr. Nelson?
It's a very major issue. I think we've wanted, can we have a pause to just discuss that and give you an answer, please?
Yes, that's fine. Mr. Nichols, I'll let you come in.
Hi there. I'm not sure if I can ask a question directly to Steve or Stephen McFarland or through yourself, but it was more around what he would be expecting the inundation modelling setup to be from SEPA's perspective. What kind of model are you anticipating?
Mr. McFarland can answer that if he's able to. It might be something better taking offline, because it doesn't. It's not. I don't mind what model you use. It's more the outcome I'm interested in. I'm not an expert in flooding issues. I just rely on the evidence I've got. But I would encourage you to both discuss this offline, so that when the information is provided, it is going to be acceptable, and it's something people are expecting to see in a format they expect to see, rather than having work that is not what they need or what they want.
Happy with that. Yeah. Yeah, I think that sounds sensible, ma'am, to take the discussion offline.
But I would encourage you to have that discussion, particularly if parties are expecting me to rely on this new piece of work, because there's no point doing this new piece of work if it's not going to be in a format that is acceptable to SEPA. Mr. Nelson, if you had a chance to consider.
Sorry, ma'am, just to for the avoidance of any doubt, we'd welcome further engagement, and happy to liaise with the appellants in that regard to ensure that this further work does meet the SEPA requirements that have been set out.
Thank you. Mr. Nelson?
Thanks, ma'am. We discussed that. I'll pass it over to Mr. Sullivan to make our points on this.
Thank you, ma'am. I suppose having discussed it amongst ourselves, the question you've asked is, should you consider this new information? Would it address the concerns raised by SEPA? And then should you desist or delay your decision until it's received? And I suppose our initial start point would be that although the appellant has said that the work has obviously been commissioned to address the points raised by SEPA, it hasn't been scoped by SEPA at this point. And we have no guarantee then, having not had eyes on any of the work today, that even if the information is submitted, that it would address those concerns raised by SEPA. And then if we follow that through, even if it, hopefully did address the significant concerns that have been raised by SEPA, it would then follow, well, what are the implications of that in terms of, is there further mitigation? How does that affect the plots? These things, again, are still unknown to us, and it's unclear to the council whether it's the purpose of this appeal to work through those issues, and why, since we requested the strategic flood risk assessment in June 2023, why it wouldn't have just been addressed as part of the initial assessment of the application.
Madam, if I may just comment on that. Indeed, that's a very good question from CEC. The appellant would like to ask the question back. Why has it taken so long for the information to be detailed? It is interminable, and it's gone on and on and on. And I think it would be inappropriate if this appeal was delayed any further. It is quite clear that there are pieces of information which have been requested. This is noted as a holding objection requiring further information. It's nothing specific. It's basically what somebody wants to make up, and we want this, we want that, we don't want this, we don't want that. We don't know what we want, but when we find out what we might want, we might want it. At this moment in time, we've got some specific information that was finally detailed on the 22nd of May, after several times of requesting it to CEC and SEPA from November of last year. All that correspondence is with the reporter. No one can explain to me why it took 5 months to come up with the information details that were requested. As soon as we got it, we got on with the work. I wouldn't like to see this set of circumstances occur yet again with basically, oh, well, thank you for that. Now we want some more information. We're going to keep our holding objection, but we're not going to tell you what we want in detail because basically we can't specify it or we don't know. It basically is just getting round in circles. I really think for that purpose, the Section 42 appeal decision can take place because any further requirements of SEPA, etc., can be dealt with. I am, of course, very, very pleased to hear that CEC and SEPA intend to engage with us, and in particular with EnviroCentre and, if necessary, DHI, because we've been asking for this engagement for a long, long time, and it has never taken place. That's on the record. It's actually been put in writing that basically, why will you not agree to the consultation? We've had holding objections before. We had one on the Inner Harbour revetment wall, which turned out to be basically baseless. I would dealt with that with SEPA, the officer at the time. It was because a CEC had misdescribed the development to SEPA. And I actually pointed out it's just a wall. It's an Inner Harbour revetment. Oh, well, it's supporting the development. No, it's not. It's a platform development. No, there's no platform development anywhere on the site, nowhere that I'm aware of. Oh, in that case, finally, I'll withdraw my objection. That's the only call that took place. This is not unique circumstances here, which is why we are trying to get this through so we can get on with the development. We don't want to be have any more unnecessary delays or obstructions. But we're conscious of the fact that the local authority and SEPA are entitled to request information. We'd like them to actively specify what it is when they want it, and we will actively respond as we are doing at this moment in time. But I'm just a little concerned to hear, oh, well, what further report might you require, says Martin Nichols correctly, and there's no response. We don't get one. And that is the issue here. That's what this is all about. That's what this appeal is about. It's about a time extension because basically the time is just running on, and you can't get on with the development of such complexity with various different sites and uses without the master plan, planning permission in principle being your framework. That's what this is all about. And that's why I say to you that I don't think it should be sisters. I don't see that argument works.
Okay, and I totally understand your position. What happened in relation to the revetment and your discussion with SEPA in relation to that one is not an issue before me. It's not for my concern. SEPA may want to comment that, but it's not relevant to my decision making. I think the point Mr. Nichols was asking, and I didn't, to be fair, let SEPA come back and answer that because I don't think it's necessarily appropriate for this hearing to have a discussion on what kind of modelling should be used. It's not relevant to me. I just am interested in the end conclusions. If Mr. McFarland wants to comment on that, he's entitled to, but I did come off because it's not relevant to me. So I think that's maybe slightly unfair to SEPA to say they didn't comment on it today. Can I just come back to the council because they had their hand up first?
Thank you, ma'am. It was just to clarify a couple of points that Mr. Price had raised. In particular, I think the frustration from the case officer here is fairly tangible in that we did request on the 12th of June 2023 a strategic site-wide flood risk assessment. And in your response the day after, in short, you told us that it wasn't going to happen. So I think very frustrating from our point of view. We have tried to work with SEPA and yourselves to try and resolve these issues, but in the absence of a strategic flood risk assessment for the entire site, I feel like this discussion is slightly stunted because we just don't know the extent of the flooding. As Cameron had mentioned at the start, we don't know the extent of the flooding. We don't know where the water is going to go. We don't know what plots are going to be affected. We don't know what the land raise has to be. We don't know any of this stuff. We have requested it. You've told us no. So unfortunately, this is why we're in this position.
Okay, I totally understand. What's going on between the parties also isn't that relevant for my determination. I'm based on the evidence before me, and I'll have to conclude whether I determine on what I've got and whether I think that's sufficient for the point we're at in this part of the appeal process. Mr. Gregg, do you want to come in and I'll go to Mr. Nichols?
Thank you, ma'am. Yes, I'd agree with what you're saying there. We're not here to discuss the revetment application and the correspondence that went on there. Again, I need to reiterate, SEPA don't accept any insinuation that that SEPA have failed to engage or that they've been unclear in their requirements. They've, we go through the detail of the correspondence, but it's not going to, I suggest, be of much assistance to you, ma'am. And I don't want to get dragged into a mudslinging competition. The fact of the matter is that SEPA require a flood risk assessment in order to properly assess flood risk at the site, and that assessment should be done in accordance with the development plan. I appreciate you stated that it might not be of assistance to you to hear from Mr. McFarlane in response to Mr. Nichols' query, but we're very happy to provide some a response on this call just now, if that would be helpful to you. We're not unwilling, is what I'm getting across.
I'm happy for you to make a comment on that, just so it's on the record if you feel that's necessary. Happy, Mr. Farland, to come back to answer Mr. Nichols' comment earlier.
Yep. Okay. Thank you, ma'am. Mr. Nichols, yeah, all I would say is, I mean, we don't specify a particular model or approach to take. You guys are modelers. You know what you're doing. We've given you what we want, which is we want to know where the water goes. I mean, most standard inundation models should do the trick, but the choice of which one you think is appropriate and how you use it is up to you. And we will comment on the outcome of that. I don't think it'd be appropriate for us to tell you exactly, and I'm sure you wouldn't want us to tell you exactly how to undertake that work. But a standard approach to the inundation mapping, checked, usual sense checks and so on carried out, and that I'm sure will be what we'll look at then.
Mr. Nichols?
I'm happy to talk further about that. Sorry for
interrupting. Thank you. Mr. Nichols?
Yeah, thank you. So inundation modelling, I take that to mean spilling water on the coastal boundary into the domain of the model of the site itself. So that model just spills in, and then the terrain determines where it goes.
Yes.
Yep. So I think that's all determined by the levels and the design of the site. So it's important in this context in terms of a master plan. When we're dealing with a master plan, for a site that will be developed in several phases to different designs, that context is important. I think that's just the point I would make.
Okay, I'm conscious, Mr. Gibbons, you've not had a chance to say anything. I just wondered, your concerns were mostly on the next part we're going to come on to, which was the breakwaters. Is there anything you want to add at this point in relation to what you've heard?
Well, I could add something in terms of the effect Storm Babbitt had, excuse me, here at the harbour in terms of real life. Nothing to do with modelling. So I don't know if that would be relevant to explain what actually happens when a significant wind arrives with a significant tide.
Yes, you can comment that. We've already had comments on what may happen from Mr. Price, so you can give your view.
Okay, so during Storm Babbitt, the wind was coming from the east of the harbour, so over the eastern breakwater, as was mentioned, and 2 yachts in the harbour, in the eastern harbour, sank, and a trawler in the eastern harbour sank. So there was a significant amount of water coming over that eastern breakwater and into the eastern harbour. On the western harbour, which the seawall only runs up to the northwest corner, the southwest corner, there is only a mud or dirt sort of wall between the southwest corner and Esperanto Wharf, and significant amounts of that washed away from that same event. So when I first moved here in 2013, there was a significant amount of earthworks built up on that western side of the harbour. That's all been flattened now. And a horseshoe-type bay that sat behind Esperanto Wharf has been filled in. Now that has a significant amount of water and had a significant amount of water during Storm Babbitt as well. So there was a significant overtopping on the western side and a significant amount of washing away of that dirt rather than a concrete type seawall that exists on the south side of the on the western harbour. So as I said, a significant overtopping on the eastern side and a washing away of the mud, sort of not really a wall. It was just the western side's just really a border. A significant amount of that washed away at that same time. I hope that was helpful.
Thank you. Mr. Frecklin, do you want to comment?
Yes, just a point regarding the modelling and the scope of the modelling, which may become kind of elaborated as we go forward with discussions between SEPA and CEC. Just to say that we have the appellant, our client's full support to commission reports and modelling for exactly whatever they determine we need. And hopefully that would remove any future debates as to the validity of the results of a report. So whatever needs to be done, it will be done. Just wanted to make that point. Now, Mr. Gibbons gave an account there of Storm Babbitt, and he was describing the Western Harbour, and it may not be relevant to your current considerations, ma'am, but I just wanted to say that since Storm Babbitt, we've carried out a significant amount of additional work to add stone to form a temporary revetment in the Western Harbour, which has secured the line of that part of the edge of the land, and will keep it secure until such time as we can construct the inner harbour revetment. So it's quite a different situation now than it was during Storm Babbitt.
I was actually going to ask if anything had been done since then, so thank you for that. Okay, turning back to the agenda, I think I'm clear on what SEPA's concerns are, what the council's concerns are, and how parties think they should be addressed going forward, whether by new information or through conditioning the permission should the appeal be granted. So I'm happy to move on from that. Question B was more about whether it was reasonable to require a strategic approach to flood risk assessment given the existing development and infrastructure on the site. And actually, I think I understand party positions on that. I think we kind of covered that, and it relates to how the inundation of water through the site. And I understand that the appellant's view is that actually there is the infrastructure, it's a certain height, and therefore separate plots come forward separately with their own flood risk assessment. So I don't think I need to say anything more on question B either. What I was proposing to do before the next part of the agenda, the next questions are really focusing on the breakwaters. So I was proposing we take a 10-minute break from here until 11:45, and then come back and we'll start just on the breakwater discussion. It may be that some of these questions kind of overlap rather than take them separately. But if we come back at 11:45 and we'll start the agenda, what to do is just switch your cameras and your microphones off, stay on the call, and we'll come back at 11:45.
Thank you.
Thank you. Okay, welcome back everyone. I'll make that 11:45. Let's wait for a few more cameras to come on to make sure everyone is here. Okay, great. I will just continue. So we're at point C of the agenda. This was really just to focus in on this whether it's reasonable to class the breakwaters as not formal flood protection measures. Now, my understanding is that they predate legislation that SEPA referred to, and therefore, for that reason, they are not viewed as formal flood protection measures. Just wondered if is that view reasonable to take, if that is the case, Mr. Gregg.
Thank you, ma'am. Sorry, I was just getting us off mute there. The SEPA's position is that, as you say, these are not formal flood defences. It is not, as I understand it, so much the age of the defences, but the purpose of them and the fact that they haven't been adopted by any statutory regime. But I'll pass you over to Mr. Spalding, who will be able to give you a bit more detail from the SEPA side.
Thank you, Anne. Yeah. So we do acknowledge that the breakwaters do appear in OS mapping available online through the Library, National Library of Scotland, and that's dated from 1853. But it is clear, and we accept that there has been some form of breakwater structure present at Granton, prior to the relevant flood protection scheme legislation. We do accept that. Notwithstanding that point, we remain of the opinion that we think it is reasonable to take the view that they're not formal flood protection measures. Internally to SEPA, we have had quite a long-standing position now that sort of any structure that might offer some degree of flood protection, but it's not been brought forward under the relevant legislation. So either the Coast Protection Act, Flood Prevention Act, or the Flood Risk Management Act, they should all be regarded as an informal flood defence. And then we typically request model runs within the flood risk assessment with those structures removed, and that then allows us to have sight of those model runs of what the likely flood risk area might be if those structures were no longer in situ, or if they failed, that sort of thing. And we typically adopt that stance for several reasons. The kind of first and main of which is that the original design and the construction of those structures is typically unclear. They were never, typically not designed to function as a specific flood defence in the first place, and then therefore, because of that, they're very unlikely to offer the appropriate sort of standard of protection that would be necessitated by NPF4. In this case, the breakwaters appear to have kind of been designed principally for kind of protection of the marina rather than an actual flood protection to the kind of land behind them during extreme events. So I'm just getting a little bit of feedback. Too sure if someone's left their mic on. Second, I think at present, the current condition and the structural integrity of those breakwaters is unknown, and that in itself leads to kind of more uncertainty. We don't really know the risk of failure at this point. And then lastly, there's no real guarantee of the long-term maintenance or kind of management, and that includes inspection and repair regimes, and it's potentially unclear in terms of the future ownership responsibilities as well. Ultimately, who has responsibility for those structures into the future? There's a lot of uncertainty to roll around that. I think it's appropriate to mention as well that Policy 22 does state that existing formal flood protection schemes, they can be taken into account when determining flood risk, but the SEPA position statement on development protected by formal flood protection schemes is very clear. It's very explicit that formal schemes have to be managed by an appropriate public body that has appropriate responsibility for its long-term maintenance, and that also, as I've mentioned, has to have been brought forward under the appropriate legislation. So as a kind of summary, for a structure to be considered within a flood risk assessment as one that provides flood mitigation and it forms either a full flood protection scheme or a distinct defence, it has to ultimately be designed, constructed, and then maintained explicitly for that purpose, and then adopted by the kind of relevant authority in question. As far as we can tell from the kind of the background research that we've conducted, the breakwaters don't meet those structures as a formal structure either. And I think recently as well, we're confirmed that the breakwaters aren't owned by the council either. But yeah, I think at this point the position statement from SEPA is quite clear, and And it's also worth noting that the primary purpose of a flood protection scheme is to protect primarily existing development. Is not really meant to facilitate new development as well. So even if the breakwaters were to be considered, a formal scheme at some point in the future, we don't think it would be appropriate to rely on them as a kind of sole form of mitigation for new proposals, which I think is essentially our position.
I would just add to that, ma'am, that SEPA's position, as you'll be aware, has been endorsed by reporters in previous decisions, including by your predecessor in this case, and indeed the reporter in the Plot 35A case, which was in terms of the one that's already been decided, and indeed by appeal decisions which were referenced by the council separate to this particular site.
Yeah, thanks for that. No, I'm aware of that. Before I go to you, Mr. Price, can I just ask the council, I suppose, what their role is as Coast Protection Authority in relation vis-a-vis the breakwaters themselves, and how you would step in for doing any maintenance, and kind of drift on to the next question D, in relation to the wording you've looked for your planning obligation. I just wonder if you could just give me an outline of what your obligations are in relation to being responsible for the long-term maintenance of the breakwaters.
Yes, thank you. I'm Gordon McComish. I'm the flood management manager, and we look after the coastal defences for the council. The breakwaters, we don't have any obligation on these breakwaters. We're not a harbour authority, so we've never maintained, never inspected these in the time that I've been involved. So we do carry out our own coastal inspections, which includes council assets and private assets. So we do inspect private assets and notify others, and these breakwaters are not included in that obligation.
Can I just clarify, you said that you're not the Harbour Authority. Are you the Coast Protection Authority?
Yes. So we are the Coast Protection Authority for Edinburgh, and that covers the whole coastline from the Forth Bridges all the way to East Lothian. But it does not include the Forth Port harbours, so Granton Harbour, Forth Ports Harbour, it doesn't include them.
Is that because they're the Harbour Authority?
I believe so. I wasn't aware of the Harbour Act until yesterday, so it's not something that falls within my remit. And it's certainly not something that we've ever inspected. I've been with the flood team and the structures team for 33 years, and we've never inspected these in that time.
Okay, that's pretty clear. Mr. Price.
Yes, I think this applies to both SEPA and CEC. I'm a little bit confused here because the Western Breakwater was strengthened based upon an application reference 05/01614/FUL, which was consented to by CEC 270309, and that's the wall on the, I have to call it the Western Breakwater Wall, but it was a strengthening works required for the development by Forth Ports, and therefore this work was carried out pursuant to a statutory consent and after the legislation. So it may be inappropriate or incorrect, that would be the right word, to say that that's not a formal sea defence. It looks like it may very well be, or it's been overlooked that it could be. It was certainly required for the development of the plots, because I looked at the papers relating to this application. I don't know whether, Gary, when you looked at it, you saw any input from SEPA to it, but I believe they were consulted. But I haven't actually seen what the result of that consultation was. That's the first point. The second point is that, in fact, the council do own some flood defence adjacent to the eastern breakwater, because they acquired that under a CPO in respect of the future tram line works. So there's a section that they own. And hopefully, Madam, you've received the updated title plan, which was sent to you yesterday. And we've attempted to identify outside of the red line the sea defences as well. We thought that was appropriate for you to see who owns what, bearing in mind the size of the breakwaters owned by the other parties is somewhat indeterminate. We know that it's hundreds of thousands of tons of rock. We know that it extends out at 6 to 7 meters into the water. I can't tell you the depth. And that applies to the western breakwater owned by a company called Granton Assets, which dates back to what you were just told, to the original construction in 1850 odd by the Duke of Buccleuch. It's owned by a company called Granton Assets, which is actually a Buccleuch family company. They took the transfer in 1909. The other section that we've referred to on the plan is owned by Forth Ports as in their registered title. Again, it extends some 6 or 7 meters out into the water and goes down to an extraordinary depth, again, with literally thousands of tons of rock. Yes, they are predating the legislation, but that's who owns it. And in respect of the responsibility for the sea walls, the quay walls, and the sections owned by the appellant, they are all contributed to by the title holders in respect of the Granton Harbour estate under the Section 75 agreement, deeds of condition dated 2003. I know there'll be a separate hearing to deal with Section 75 matters, but just a matter of fact that it is on all their titles and everybody is responsible because it's on the titles to contribute. So basically they are maintained, and indeed they are inspected, and indeed the owners of the western end of this have actually carried out inspections of the sea wall, because that's the bit that they own, that sits on the land and is supported by the breakwater. And there are some works of repair where some rock movement or some water damage, pretty minimal. There's no sign of any movement on the overtopped bit, the strengthening works that I've referred to. So I hope that just makes it sort of, might make it too complicated, but it's not that clear. I can't honestly say that they're not formal flood defences when part of it was formally approved by CEC and presumably approved or advised to SEPA at the time. And the works were carried out, and they were carried out for the specific development of some sites which are close to the water.
Sorry,
My
Ma'am, you're on
understanding
mute.
is that, yeah, on either the seawall in the middle, which is owned by Edinburgh Marina Limited, and then on either side is a breakwater, and the outer side that is right next to the sea is the Buccleuch Estates Limited, and the inner side of the eastern one is Forth Ports, and on the other side it would be Edinburgh Marina Limited. Is that
and beyond that, Granton Assets.
Sorry, yeah, Granton Assets. It's the outside parts of both, the bit that kind of touches the sea.
In a practical sense, the bit that supports the wall that's owned by Edinburgh Marina Holdings Limited is supported by the breakwaters owned by others.
Either side, yes.
Yeah, they have a duty of support. But your question really refers to the fact that is it reasonable to take the view that breakwaters are not formal flood protection measures? I would say brackets, yes, but with the exception of the formally approved section of the western wall, which was a statutory approval by CEC to wall strengthening specifically to deal with the flood prevention works for the future development of the sites that actually border the wall. So that is something which it was before our time, but that's what's on the file.
Right, I'll let CC come back to us in just in a minute. I'd like Mr. Gibbons to comment from an owner's perspective, your obligations and your service charge.
Yes, a complicated picture because my own interpretation of the title deeds is that only those owners that are commercially benefiting from the harbour area actually are responsible or liable for the maintenance of the breakwaters and middle pier. Mr. Price says everybody. I'm not sure exactly what that means, but in terms of my own interpretation, is that it's only those that are commercially benefiting. Now, we have been charged since Mr. Price's company took over in 2014. Prior to that, we were charged nothing towards the maintenance of the breakwaters and the middle pier. And in 2014, a charge was introduced, £120,000 a year for a sinking fund for the replacement of the harbour defences, and a separate £30,000 a year annual maintenance and £33,000 a year insurance towards those breakwaters. So Mr. Price's company obviously took the view that we are liable for that, and that has been in a dispute between myself and PIP Asset Management since 2014. So I don't accept that I am liable.
And Mr. Charles, your position would be that this stems from the existing 75 agreement, Section 75 agreement over the site, which obliged Forth Ports and I guess their successors to impose that obligation on owners of the site.
Yes, this agreement was put in place as part of the Section 75. It was put in place in 2003. Mr. Gibbons is entitled to his opinion or views, but he's incorrect insofar as it's on all the titles of all the sites, all the buildings, and all the flats. It is the only people that are currently not liable to pay are those that are excluded under the deeds of condition, which are basically undeveloped sites of a residential nature. There are over 840 individual titles who all have this obligation to contribute. And the figures quoted by Mr. Gibbons are in fact incorrect, because we started off hoping in front of Mr. Gibbons that we could insure these walls, but unfortunately we found out that we couldn't. So we can only have a certain limited amount of insurance, like public liability, etc. But be that as it may, we're not here to discuss that part of the detail. The simple matter is that, and we can discuss it further on hearing 3 tomorrow, which I think is the relevant place to do it. But it's just a matter of fact that the responsibility for the maintenance and repair, renewals, etc., of the sea walls which are owned by the appellant is passed on to all the title holders, including, of course, the appellant. I mean, so they're not excluded, everybody's got it. There are some exclusions where the sites are not developed. And that's the position.
Okay, Mr. Gibbons, do you want to respond to that?
Yes, it's just that my title deeds, the burden sections of my title deeds and the burden sections of Mr. Price's, who's acting on behalf of Granton Central Development, the burdens in relation to the public realm area are identical. Therefore, if I am liable, then Mr. Price's owners, Granton Central Development, have been liable since 2014. And Mr. Price actually wrote to me in 2014 to say to me that both developed and undeveloped sites are liable. Hence, Leithor Housing Association, that had the plot next to mine that was undeveloped, had been charged. the same public service charge up to the point that they put up their building. So if Mr. Price is saying that I am liable, then his company is also, or the company he represents are also liable and should have been paying these charges since 2014, which would have amounted to a significant sinking charge, a sinking fund in the event that maintenance is required or the replacement of this structure is required. But in fact, they subsequently wrote to us to say that there's no money in these funds. And it's a mystery as to where these funds have gone to.
I'm really interested in what the funds are, or it's just who's responsible for the maintenance of this. We've got the seawall now. I think Mr. Price said that undeveloped residential sites are excluded, but his company does pay as far as it is included in other areas they will own, is my understanding of what you said, Mr. Price.
What Mr. Gibbons seems to confuse us with as being a principal. We're the agents for the owners. GCDL does not actually own the infrastructure, so that's wrong. If he looks at the communications, it's owned by Granton Holdings Limited, and they are the ones that instruct us to collect and manage on their behalf. He refers, not that I want to get into the debate about a sinking fund, but as Mr. Gibbons has said, I haven't paid anything. Well, if you haven't paid anything, there'll be no funding from him in the sinking fund. And so if people don't pay, there is no sinking fund. This is all being addressed at the present time. But the issue before us here is in respect to the Section 42, and the question that you've asked, which is basically who is responsible for the maintenance of those items which are owned. And I've told you that is how it is dealt with. I can't speak for Forth Ports why they didn't actually deal with it prior to us coming on the scene, but they didn't for whatever reason. They hadn't set up any basis of management of a formal nature, no sinking fund, no nothing.
But I mean, that is what
it's a bit irrelevant.
Yeah, that is relevant. We are now. It's very clear from what you've said and the title plan that you sent who owns what and who is liable for maintenance. I'm going to I'm just going to go to the council just now for just a point on. I'm assuming the council, you've seen this plan that was circulated yesterday. The case officer was asked to send it out. Now, I think you're quite clear you don't own anything to do with the breakwaters of the seawall, and that's borne out in the plan, subject to the very bit at the bottom, which is the sea defence, slope and masonry and revetment owned by the council. But from the other parts of the breakwaters, you don't own either the breakwaters or the walls. That's quite clear. I think that's your position. And I suppose then you accept you're the Coast Protection Authority, and therefore I wonder, given that position that you're not the owners but the Coast Protection Authority, how does that sit with the planning obligation you're looking for the Western Breakwater in any new Section 75 agreement? Is kind of point D on the agenda?
Yes, ma'am. So then the Section 75 point was obviously the dispute that the flood risk assessment is adequate and that the flooding issues are resolved. But if we're accepting that flood issues can be resolved on this site, and as relying on these breakwaters as flood defences, then it's to address the issue that it's not. We've just touched on, I suppose, of what the maintenance position is, the number of owners involved, number of parties involved. That there is a proper maintenance procedure in place, and that the council has proper steps under the legal agreement that can be taken if it's not been properly maintained. As I think has been touched on in terms of is it a form of flood defence or not, and I really agree with SEPA of why it is not. It's certainly not the case that the Section 75 in any way is turning it into a form of flood defence. The very reason it's necessary to have the Section 75 obligations on this is because it's not a form of flood defence. It's not under the control of the council. It's not or a public authority. It's a number of third parties, and the development is reliant on these flood defences to protect it. And if that's the case, we'd say that in terms of granting consent, it's critical that there's a Section 75 obligation in place that controls the maintenance, allows already reflection on that at a frequent basis, and has steps if it's not been carried out properly. So that's where we're coming from with Section 75.
So can I just clarify a point you made there? So if there wasn't a flood issue, in your view, you wouldn't be looking for any obligation in relation to the breakwaters?
No, we would be looking for it, because we're saying that the breakwaters they form part of the flood defences of the site, and if you're relying on them as saying that they are there as flood defences of the site, then for those significant issues in terms of the planning policy of being properly flood defended, then it's critical that they continue to work for the lifetime of the site, and that's why Section 75 obligations needed to ensure that is an ongoing issue, because otherwise the council does not have any direct involvement in that, as my colleague has previously outlined, in terms of our involvement on the site and in these flood defences.
So if the flood risk assessment shows that there's, in an undefended scenario, that there's no flood issue, you wouldn't look for any obligation in the Section 75 agreement?
The point of having a flood risk assessment for the strategic assessment for the site, and that showed that, then that might well be the case, ma'am, but I would submit that we've certainly not seen that to date.
I know, I understand that. I'm speaking hypothetically. If this updated flood risk assessment showed that there was no issue in an undefended scenario, you wouldn't look for that obligation? Sorry, was that no? Sorry, can I cut off?
Sorry, ma'am. Apologies, ma'am.
Oh, sorry.
Apologies. Yes, ma'am. I mean, I think if we were confident that for an undefended scenario for the lifetime of the development, using worst case scenario for it in terms of the proper modelling that's been outlined, the proper guidance that's been outlined by SEPA, was all in place, and that there was no issue with an undefended scenario for the site for the lifetime of it, then there wouldn't be a need for that Section 75 obligation.
Okay, and then turning it on its head, based on the information and your position so far, which was on the FRA 2024 and SEPA's closing objection, you're looking for this. I suppose, bear in mind that you don't own seawalls in the breakwaters, and you're saying they're not formal flood defences in your view. What's your locus for this and for the requirement that you would step in to carry out repairs and claim costs back from the appellant? On what basis would you be entitled to give a notice to carry out the repairs? That's the bit I'm disconnect in my mind. If they're not formal flood defences, but you can step in, do repairs and seek repayment from the appellant, on what basis do you do that?
So there's two approaches, ma'am. So I think the Section 75 agreement was to give us that locus if we were saying that we're reliant on those flood defences to meet PPA-4 policies, and to properly have a proper flood defence in place for the site. Then we were saying that necessary to have those Section 75 obligations in place for the proper maintenance and step-in powers directly in respect of this development. There's the broader powers of the Coastal Protection Authority that the council also is, as we've touched on, and in terms of any owner of flood defences and their failure to maintain it, that we can step in and use our coastal protection authority powers to compel them to carry out works, and should they fail to do those works to properly maintain and repair flood defences, then we can step in and then we can recover it under that legislation.
Sorry to be really pedantic there, but you're calling them flood defences in this context. So are they flood defences from your perspective as the Coastal Protection Agency?
Well, I think what we're saying, ma'am, is there's the differences of whether it's an informal flood defence or whether it's a formal flood defence. I think SEPA's gone into some detail as to what constitutes a formal flood defence. We absolutely agree with that. There's still serving some purpose as an informal flood defence without any of the protections in place that a formal flood defence would have, in terms of it being by a public authority, being under the relevant flooding legislation that has been constructed. But we recognise that the structures exist and they serve some level of purpose as an informal flood defence at the site. But they were principally built for protecting the boats in the harbour, as what they were originally designed for. But
ultimately, if you treat them even as an informal flood defence, the fact that you're saying you can step in as the Coastal Protection Authority, does that not suggest that you're managing them? So if they got to a point where they were in such disrepair that needed works carried out, you would step in to maintain them. Therefore, if SEPA's criteria that they need to be managed by an appropriate public body with appropriate responsibility for long-term maintenance, does that not fall into that category, the fact that you can step in and do that, which is what you've based your Section 75 agreement on?
Definitely not, ma'am. I mean, I think the point is, as Mr. McComish has outlined earlier with it, is that we're certainly not, as you pointed out, we're not the owners of these defences at all. We don't some maintenance.
I guess SEPA's test wasn't about ownership, it was about management and responsibility for long-term maintenance. It doesn't refer to ownership. So there's a slight difference there, I think.
But we're not managing it, I suppose is what I'm saying. We've not no role in managing it. What the Coastal Protection Authority can do is, if there's an issue is identified with flood defences that are not owned by, not controlled by a public authority, is to compel the owner to do the proper maintenance and repair that they should be doing. But that's not the same as us having a management over these defences. It's discretionary power.
But it's what you're seeking in the Section 75 agreement, putting a management structure in place.
I think the Section 75 is certainly attempting to put a stronger process in place that for proper maintenance of the site that is with it, and then this is under the control of the planning authority. But it's still a case that is owned by the parties. The responsibilities for the maintenance are with the parties, not with the public authority. It's not changing with this into a formal flood defence.
But you get the ownership and maintenance can be completely different. It doesn't necessarily follow that the owner has to maintain. You could have another party who is maintaining. Can you get the distinction?
I absolutely get that in terms of the site conditions and how that's been set up, and that separate parties can have maintenance responsibilities. But neither Section 75 or the Coastal Protection Authority powers it's meaning that the council has maintenance responsibilities. What the council has is powers where there's a failure to maintain properly by the owner or by the parties that are meant to be maintaining it.
And you'd still take the view that, notwithstanding you've got these powers and you're bringing these breakwaters in to your kind of remit as Coastal Protection Authority, that would not make them formal flood defences?
No, it certainly doesn't make them formal flood defences.
Coming to Mr. Gibbons, then Mr. Freckleton, and I'll come back to SEPA for any comments you want to make on this part of the discussion. Mr. Gibbons?
Well, it's just to follow up what the council gentleman was saying a minute ago. Thank you. It was just that when I read the outline planning application in 2003, it said that Forth Ports PLC was going to set up a management company for maintaining the harbour defences, or whatever we're calling them. So my view is that body is responsible for it, and therefore the charges that have been incurred by Mr. Price's company on residents here at Granton Harbour, in my opinion, are unjustified. So, as I say, I agree with what the council gentleman is saying. It was clear in the outline planning application what should have been the process for maintaining these breakwaters, and not what has been developed since, in my opinion.
I mean, what happened with Fourth Ports is, again, not my name, but I hear the point you're making. Mr. Freckleton.
Yes, thank you, ma'am. Just to perhaps, this is a complicated situation due to all the previous arrangements and the way it's been set up in the history going back to the 1900s. But to get down to the nitty-gritty, and I think the question you're asking, there is an existing mechanism in place to maintain and repair and to pay for those maintenance and repairs. There is also the ultimate responsibility of the CPA to step in if things do go wrong. So that is all in place. And the question of whether a new Section 75 agreement could solve a problem. The problem doesn't necessarily exist, and a new Section 75 agreement is not capable of being implemented. I know we're going to come on to that in a later hearing, but you saw the map of 840 title holders and how we would impose new obligations on them. I do not know, but there are existing obligations on all the owners to maintain and repair the sea defences.
We will come on to that, in Session 3.
Yeah, thank you.
Mr. Gregg, do you have any comments from SEPA's perspective? I've kind of done, I suppose, questions C and D together.
I don't think we have anything further to add, ma'am. You have our view that these are not formal flood defences. They don't meet the long-standing definition that SEPA has for formal flood protection schemes.
Would that view change in light of the Section 95 obligation the council are seeking?
No, that wouldn't have an impact.
Mr. Nichols?
Yeah, thank you. I was just going to state that obviously the breakwaters' purpose is to break waves, and they would have been constructed to protect all aspects of the harbour behind it. But my query was whether there was any process undertaken at the point that the Act came in to assess whether these should be formal flood protection, a formal flood protection scheme, or whether there wasn't any assessment undertaken at all. Yeah.
Maybe the council can answer that, Mr. Nelson, or maybe you can't. I don't know.
Not as far as we're aware, ma'am, in terms of any that sort of assessment.
Okay, just capturing where we're at in the agenda. I think we're straight into a couple of our points. I think I'm happy that I've got enough on question C, and I understand parties' positions in relation to D. E, I think we've covered with reference to the ownership plan provided by the appellant yesterday. And I don't think anyone's disputing what that shows. Mr. Price, I'll just come to you. Mr. Nelson, have you seen the title ownership plan, and are you broadly happy with that?
I think you've had our previous submissions on what we'd say on ownership in our 4th of April submission. So I don't think there's much value in repeating all of that. I don't think the plan that's been produced at the 11th hour, we may look at unreasonable behaviour and expenses in due course, but that doesn't change our position in terms of what we consider the ownership position to be and maintenance position to be.
Yeah, no, I've looked at the title deeds you provided, the title sheet, which was a bit of a jigsaw to self-tape together. So I've got all that, and I've seen the updates to the title sheet you also put in, which shows the transfer to Edinburgh Marine Limited. So I do have that information. And I think we have covered the ownership and the maintenance points in questions E and F. Mr. Price, is there anything you want to add?
Yes, just CEC have not commented on the consent given to the strengthening of the western wall, shall I call it, or western breakwater wall, whatever was described in the planning consent. So would that therefore be classified as a formal sea defence and fall into their responsibility that you've outlined?
Mr. Nelson, do you?
I didn't hear a response to the point I'm making. I mean, to be honest, I really don't know, but it's something that I found, and it goes, right, okay, so is it? It was done after the legislation. It was a detailed application. It's got engineers' reports, by the way. I did see reference to those. So a lot of engineering studies were done as to the requirements of the council and presumably anybody else that was a consultee. So it was done as a western, it's described as the description of the application consent, western breakwater wall strengthening. So is that now, would you say that therefore is a formal sea defence because you approved it?
No, ma'am. I mean, that's a formal planning consent for what it's described as doing of strengthening the seawall. That I think, as SEPA has already set out, what constitutes a formal flood defence under the relevant legislation in terms of what flood defences are, and that isn't being progressed under those legislation to create formal flood defence. So it doesn't change anything to our position. That's not a formal flood defence.
Okay, no, I understand your positions. Mr. Gibbons, do you want to come in? You've got your hand up, so I'm just wondering any final comments to make.
Apologies, I think that might have been a leftover, so apologies.
Oh no, that's absolutely fine. I just wanted to make sure you didn't miss out making another comment.
Thank you.
I think I can go into G, which I'd asked who's ultimately liable if the seawall and breakwaters fail. I'll ask Edinburgh Council, what's your view on that?
The owners are liable, ma'am, if they fail. That's the thing we've touched on. There's the Coastal Protection Authority powers to force owners to do necessary work, and then for the council to recover costs if we have to step in to do it as Coastal Protection Authority. But it's not liability with the rest of the owners.
Okay. So you could step in as Coastal Protection Authority and recover your costs from the owners?
Yes, so yeah, because the first step would be to require certain matters to be addressed in terms of this being the failure and what we're specifying needs done. If that fails to be done, then the council can step in as Coastal Protection Authority and then cover costs from the owners.
Does the appellant have a view on that? Do you agree with the council's position on that?
Yeah, the simple answer is that they are ultimately responsible. If the owners don't repair or the owners go out of business, and anybody else doesn't pay, then that's a matter of fact. I mean, they ultimately are responsible. Whether or not they can reclaim all or part of the money from people that may or may not exist or don't want to pay, like Mr. Gibbons, then that's up to them. I mean, what can we say about it? But they are ultimately responsible. We agree.
Mr. Struthers.
Sorry, it was just to ask the question. I think the council's responded to what their powers are to enact repairs or maintenance, but I think that your question is slightly different. It's the liability if these defences fail So the question would be, is there any liability on the council if those powers aren't used? Is that what you would intend the question to be, ma'am?
Yeah, so I was going to ask, we come back to council and ask what would happen if it didn't exercise their powers to step in and therefore didn't do anything? Yeah, who is ultimately liable for the resulting situation?
So yes, we could choose not to step in or not to do anything, because we're not required to step in such a scenario. It's a discretionary power the council has as coastal protection authority, and so certainly that part of that assessment may well be, if there's no likelihood of recovery of costs of owners, that might well be a compelling reason not to step in and incur costs in the public purse that can be recovered.
Okay, so that would lead to the conclusion that there's arguably no requirement for these breakwater seawall to be maintained at all. Is that fair?
That's fair in the slightest, but I think the point but ownership and maintenance now we've already covered in terms of who's required as owners to then maintain it, and we've got the title conditions in terms of what maintenance is meant to be going on. I think what we're touching on is if all that ultimately fails, it's whether the council has the liability to step in and do something, which it doesn't. It has the option as coastal protection authority to do so if within its wider interest for doing so.
So at the moment, I suppose we were saying it's a contractual or Section 75 requirement for these to be maintained by the owners, which have been passed on to the individual owners in the plots. And if no one did what was required under those contracts when the title deeds, then there's an option for the council to step in, but it's not a requirement.
That's right, man. And I think that's partly what we touched on a little bit already on the Section 75 of why we think there needs to be other steps in the 75 to ensure that maintenance takes place to avoid that scenario occurring.
Okay, does anyone have any comments they want to make on breakwaters, ownership, maintenance? I think I've got enough. I think I understand it. The various parties' positions on that. Is everyone happy for me to move on? I was going to look at the next question, which is about if I determine the appeal and grant the appeal based on the flood risk assessment information I've got. One, what would be the risks, and what conditions, if any, should I impose to deal with that to mitigate those risks? Mr. Gibbons, I'll let you come in.
Sorry, just before you move on, thank you very much. Just before you move on, I think this position on the ownership, prior to 2003, it is my belief that Forth Ports PLC would have been liable for the maintenance of these breakwaters. And that outline planning permission in 2003 specifically addressed the question of what would happen if the ownership and responsibility became muddled by the change of ownership. As I said, the flood protection officer from the council at that time specifically addressed that point in the outline planning application, and that is exactly what has come to pass. So in my opinion, prior to 2003, there was no debating who was liable. And this debate has come about by a position that the council flood protection officer correctly predicted in 2003. So apologies if that didn't help, but thank you.
No, I saw the information you put in. I understand the issues have arisen through the transfer of parts of the site. Okay, I'll put this question to SEPA first. So what would be the risks if I ultimately decide I should grant the appeal? I won't ask you about the condition unless you've got views on the wording of the condition, and then I'll go to the council and then I'll come to the appellant.
Thank you, ma'am. I'll pass you over to Ms. Barbara for this one.
Yes, so basing just on the information that you have before you now, not on any future work, the risk is due to us not having this full understanding of the flood risk at the site and it not being fully addressed. So that would lead to a risk of the development already there plus future development being at an unacceptable level of risk from flooding. Without the information that we've asked for, we also can't be happy with any mitigation measures that might be proposed, and whether they would be appropriate or not. We asked about whether there could be conditions based on what is before you now, as we haven't agreed with the baseline design level conditions related to setting minimum floor levels or things like that. We kind of wouldn't be happy to support that now until we are confident with the understanding of flood risk at the site. If we can get to an agreed understanding of the flood risk at the site, then we would be happy if conditions came forward, but as long as the detail was based on that agreed upon flood risk assessment. So I think there were 2 conditions in the list that the City of Edinburgh Council sent through in their document 43. One was about floor levels, and one was about the existing and finished ground levels. So that's the sort of thing that we would be happy to be conditioned, but only if it was based on an agreed upon site-wide strategic flood risk assessment. We view flood risk as a fundamental consideration. It's an in-principle matter, and so we need that to be fully addressed and understood before permission is granted, and we wouldn't view it as appropriate to rely on conditions to get further flood risk information or flood risk assessments done.
Okay, thank you. That's all very clear. Mr. Nelson for the council.
Yeah, I think Mr. Sillick and Thomas will speak on this one. So I think Chris was going to speak first.
Yeah. So in terms of what the risks would be, I think I'm just kind of reiterating what George has already said is that in absence of the site-wide flood risk assessment, but carried out, to address the concerns that have been raised by SEPA, that there would be, where we don't understand the level of inundation to the site and where the water is going to go, the risk, I suppose, is then that people and buildings will be at risk of flooding now and into the long term. So it poses a risk to the buildings and a risk to human life. We have no confirmation that the site can remain safe and operational during floods, or that any adaptations can be made to mitigate the risks or the potential impacts. I suppose we'd have no confirmation, for example, even if there were mitigation measures, that they would be deliverable or acceptable to the owners, or that they would proceed with them. And so we'd have no guarantee that those measures would come forward or could come forward, were practical. So without understanding what that risk is, again, our ultimate fallback position is that people and buildings are at risk. And then I don't know if Thomas has anything to add.
Not much more to add, other than to just clarify that if being asked what the risks are, we can't answer that question. They're not understood. And without covering and without going over the technical issues we spoke about at the start, there's still outstanding issues to be addressed. And this is highly vulnerable residential development that's being proposed. And there's still outstanding issues.
And I'm assuming, I'll come, Mr. Strollers, I'm assuming you don't think it would be acceptable for me to condition it, if I was minded to grant, either having a pre-commencement condition that a strategic flood risk assessment addressing these points should be submitted for approval, or that further flood risk assessments should be submitted on a site-by-site basis.
Yeah. I mean, our principal position would be no, that we don't think those matters should be conditioned. I would agree with SEPA that I think it's an in-principle issue that needs to be determined now before any consent's issued. And again, it's principally because we really don't know what the outcome of that survey work is, and again, whether any mitigations would be practical or deliverable, and what the impacts would be there. So you're conditioning something you could potentially there be conditioning something that just isn't deliverable or practical or doesn't resolve the issue. I think in absence of the information up front, we can't comment on how it should be conditioned, and we wouldn't recommend that it is conditioned in terms of a pre-commenced condition.
But does there have to be a reasonable prospect the condition could be fulfilled?
I think that's where we're coming from. In absence of the information, it's not possible to say if there is a reasonable prospect that the condition could be fulfilled. And I suppose if the ultimate aim of this Section 42 application in terms of renewing the consent is to allow development to proceed and to provide certainty, we're still really not in a position where any certainty is being provided in terms of the flood risk assessment. We don't know what it says, but in terms of potential inundation of the site, there might be parts of the site where, aspects of the master plan can't be delivered. And we don't know what that looks like now because we don't have that information. So that, again, is there a reasonable prospect of the condition being fulfilled? I don't think we could say that right now.
Where other plots have come forward, did you ask for flood risk assessments over the whole site or just that plot?
So I can tell you what was submitted. The applications that you'd be referring to were considered in around about 2017 and 2018. So I wasn't with the council at that time, and I wasn't the case officer. But we did request certainly flood risk assessments and flood risk assessments for the plots that have had previous permissions. Flood risk assessments were provided. If I just bear with me whilst I get to my notes. So we had flood risk assessments provided in respect of plot 7B, plot 8C, plot 9A, plot 9B, plot 29 and 35, and the plots referred to by the appellant as KOPQUT. And in most cases, they were supported by the same flood risk assessment. So that was a flood risk assessment produced by Fairhurst in 2017. So they were considered largely in a group. So SEPA, as part of the previous application for plot 35A, so the application that was ultimately refused, so that's application 21/06413/FUL. SEPA commented on the flood risk assessments that were produced by Fairhurst in 2017. That flood risk assessment relied on assumptions from a previous wave disturbance modelling report produced by DHI in 2016. And my understanding of SEPA's position, and certainly we have SEPA here, so if anyone's aware of this discussion, they can comment, but the DHI wave modelling report from 2016 was based on present day conditions, so it didn't include a climate change uplift. And in terms of the modelling used, it wasn't modelling for transmission into the harbour wasn't captured. So in terms of did those flood risk assessments meet the kind of modern day requirements for MKF4, the answer would be no, that they didn't really cover the climate change uplift. But certainly they were considered acceptable for the policy at the time and for SPP, where climate change was a recommendation but not a policy requirement. So yes, certainly there have been previous FRAs.
And they were done on a site-specific basis?
That they were the Fairhurst 2017 covered a number of plots, but the applications come forward on an individual basis. The kind of flood risk work was just submitted again and amended in some cases.
Okay, Mr. Gibbons?
Yeah, as I say, just to add to what the council is saying, from my point of view, if these breakwaters didn't exist, my flat would be underwater. So I don't know if that's formal or informal, but from my point of view, there are flood defences that need to be maintained.
Okay, can I go to the appellant now and ask for your views on conditions and what the risk would be if I decided to grant the appeal?
Well, I can go first. I would have thought there would be no risk because the future development would be subject to exactly what the council has said, which is assessment on the current status of, I can call it the flood risk business, because obviously it doesn't stay still. I noticed the council have been referring back to 2016 and 17, indeed 18, but in fact there were planning applications which I know about which were submitted considerably later than that. I'll ask Gary because I've just asked him to give me the last one that was consented to, but I think that was in 2021, 2022. Basically, I don't quite know why the council wants to go back so far in time. There are much more recent examples. We didn't find any consultation responses on the later ones from SEPA expressing any view about flood risk whatsoever. I don't think there's any necessity to complicate matters by putting in a condition, but if, Madam, you wish to do that, then providing the wording is something which can be provided and it makes everybody happy, then I can't see anything wrong with that approach. But it wouldn't necessarily be something which would be relevant to this type of application. I know it's a new consent, but it's a planning permission in principle consent, not detailed consent for a site. And I think that's a very, very relevant consideration for you to think about, because I think it's slightly impractical because you've got a planning permission in principle, which is going to run on for a period of time. And as I just said, and I think you've accepted, the world keeps changing. We have all sorts of things happening with climate change. So, things will change for individual sites, and we're aware of that. I think it is something which is contradictory in itself, is that if we assume there's no sea defences, formal or informal or at all, right, this undefended scenario, then there's no necessity to make any conditions about anything. And notwithstanding the comments that have been made, there is already on the title, not a planning matter, on a title matter, a robust situation that the properties are managed, and in particular the infrastructure is managed, and everybody that are using Mr. Gibbons' expression commercially benefits, who commercially benefits. So someone owning a flat or someone owning an office or a warehouse or whatever, those that have commercially benefited, they contribute. And therefore, it is a really robust situation and doesn't have to be reinvented. Unless, of course, someone is trying to do something which they shouldn't be doing, which basically refers back to something which we'll discuss on hearing 3, which is that's probably the nub of this matter, where the council refer to the heads of terms and some obligation under clause 11 that somehow or other they should be relieved of their obligation by Fourth Courts taking over the management or control of the Western Breakwater. I'm not quite sure how they agreed to it, because it's pretty obvious they didn't own it, all of it anyway. The Breakwater, as you can see, the title was transferred in 1909, so I'm not quite sure in 2003 how they could actually agree to this. So without going off at a tangent, I believe that you are at no risk in allowing this appeal based upon your knowledge that for individual applications like 35A, a very robust regime is in place, as you can hear from CEC, judging by the number of people in the CEC room, the SEPA room, and this room and that room. There's loads of people robustly looking at this, and we're having to deal with it, which we will. And we can satisfy, we know that we can satisfy the conditions. I don't think that you should be concerned about any risk. That's my viewpoint.
Okay, Mr. Struthers.
Can I just reiterate a point that Charles has made about the fact that the individual plot developments will be subject to detailed planning application and determination, with a requirement that the flood risk assessments for the individual plots assess flood risk to the plot and the flood risk impact of the development upon neighbouring receptors. My perception, therefore, is that these development going forward doesn't have to have a mind for any impacts that are caused by development that's already consented, only for future development. And because the detailed planning applications will have to consider the impact of development upon flood risk to others, that I wouldn't perceive there to be separate risks associated with essentially granting a time extension on the master plan that is still going to require that the individual developments are subject to their own detailed planning application and flood risk assessment.
But that would only be the case if there was a condition that required them to do that. Is that?
My understanding is that a requirement for them to have their own site-specific flood risk assessment.
Okay, Mr. Gibbons.
Thank you. Well, from my point of view, if site 35B was to flood, the difference in elevation between that site and where my plot is, plot 4, is possibly a foot at the most. So if that site is to flood, then there will be significant flooding throughout my area, at least. So therefore, looking at it as a single entity, I don't believe that is entirely feasible from my point of view in terms of the risk to my flood. But that's only my opinion.
Because you're saying the water would kind of flood the 35A, it would have to run somewhere, which should be down to the level of your plot.
Once 35A is flooded, everything else above that is virtually flat. There's nowhere for that water to go other than the rest of the harbour area that's residential.
Okay, Mr. Struthers?
I'm sorry, can I just clarify that matter that Mr. Gibbons raised? Was he relating it to 35A or 35B?
The area nearest to Esperanto Wharf, the sort of northwest corner of the harbour area. So that next to the hotel and the marina, the area right in the northwest corner. I thought that was 35A or 35B. Apologies if I've got those mixed up. But that area.
I'm just trying to clarify whether the concern relates to consented development or future development?
I thought related to plot 35A and future development, but Mr. Gibbons can maybe just confirm.
Yes, apologies if I've mixed the A's and the B's.
Okay, Mr. Struthers?
Yeah, I'm still, I'm not clear whether if Mr. Gibbons is talking about proposed levels or is he talking about actual levels of an existing section of the site?
Well, okay, correct me if I'm wrong. What is the proposed level for that area, that whole area between the north, the south brickwork, the south harbour wall, and right up to Esperanto Wharf? Is that going to stay at the current level, or is that going to increase?
Gary, can you provide clarification?
Yes, certainly. The proposal is for the levels of roads, cycleways, pavements proposed for 35A to tie into the existing roads, say Hesperus, Broadway. So it will be around 6 to 6.2, but obviously we have an SWMP for that site as well. So, and it has drainage. There are drains in the roads. There's drainage through the permeable paving, etc. And so nothing in the SWMP or the FRA has indicated that water would flow from 35A, for example, across to plot 4, which is quite some distance away. Yeah.
Yeah, it's. I think Mr. Gibbons' statement is presupposed on 35A being inundated to some depth and then running off. In any case,
apologies. Yeah, exactly as happened with Storm Babbitt. Yeah. There was waves crashing on top of that area, and the water had no specific area to go. Now, if that happens again, as I say, I was prepared to remove my car from the garage on that day that the storm arrived. So I was ready to vacate my car from the garage. So I was of the opinion there was a risk there. Now, the models may say otherwise, but in my opinion, being here, I considered it to be a risk.
I would argue my point and Charles's point stands that the planning application and determination for plot 35A would have to demonstrate that no flood risk detriment is caused to surrounding receptors, but that wouldn't be the subject of what we're discussing in this hearing.
But I guess the principle is though that there's no risk to granting this one because all future applications would be required to satisfy the council that there was no flood risk. Is the point
including no flood risk detriment to existing development.
Yeah. Okay. No, I get that as being the appellant's point. Mr. Price?
Yes, a really short point. Mr. Gibbons actually emphasises how important it is for plot 35A to be brought forward for development, because what it does when storm came, it hadn't been properly infilled, it had no protection. A vast amount of work was carried out. It had already been planned, by the way, to get this underway. And we've got a temporary revetment wall, if I want to call it that, but a rock face. The protection had built up. But the safest way for everybody is to see this site developed. And that's why we keep pushing to get this forward and doing everything possible. Really, if Mr. Gibbons has concern, he should support that this site is developed in accordance, Mr. Gibbons, with the requirements of CEC and SEPA relevant to this site to give you the protection that you're looking for. Thank you.
Okay, I'm conscious getting to 1 o'clock. We've got 1 point left on the agenda, which is a discussion on the plan obligation proposed by the council. If SEPA had no real interest in this, I could move this to session 3 to ensure that we can go on to hearing session 2 at 2 o'clock. Mr. Gregg, did you want to take part in this discussion on the Section 75 obligation, or is really mapping the council and the appellant?
SEPA don't have any comments to make on that item, ma'am. Happy to leave it to the council and the appellant.
Mr. Gibbons, you may have an interest in hearing the discussion on that.
Yes, thank you.
Would you be available to attend at 10 o'clock tomorrow morning for me to take that as part of hearing session 3? It would just mean we could then go into hearing session 2 after lunch to allow the appellant's funder to come in at that point, and I could deal with this hearing session 3 tomorrow morning, which seems to kind of make more sense and use our time better. But if you're available tomorrow morning, then that session would start at 10 o'clock, and we could take it then if that was acceptable to you.
Yes, thank you very much. Thank you.
Okay, so on that basis, I think I've got enough from today for our discussion, which has been very helpful. So thank you everyone for your contributions. We will go on to the second hearing session at 2 o'clock. Again, you can just put off your camera and your microphones because it's on the same link. I'll see SEPA aren't taking part of that, so thank you very much for coming along this morning and for your contributions on that. And I'll see everyone else at 2 o'clock. The agenda is being circulated for that. And Mr. Gibbons, we will see you tomorrow at 10 o'clock for the third hearing session on conditions and planning obligations.
Thank you. Thank you very much.
Thank you very much, ma'am.
Thank you. Okay, welcome back, everyone. Just before we start formally, has everyone joined? Everyone's expecting to join.
I think we're waiting for Mr. Cunningham.
I've joined, Charles. I'm here.
You joined at the bottom, or bottom of my screen.
Okay.
Is there anyone else you're waiting for? The council team are all there, and the appellant, you're happy that you've got everyone you're expecting? Yeah. Okay.
Yeah.
Okay, so good afternoon, everyone. It's 2:01. For the benefit of Mr. Cunningham, who's just joined us, he wasn't here this morning, I'm Trudy Craggs. I'm a reporter with Planning and Environmental Appeals Division with the Scottish Government, which is known as the DPA. Just a reminder for you and for everyone else that this is a virtual hearing session and is being broadcast live. It will be stored as part of the DPA website archives and will be capable of repeated viewing in the future. And by participating today, you're consenting to being filmed and to images of you being kept in our records for historical purposes. So we had a hearing session this morning on flood risk, and this is the second of 3 that we're having on this appeal. And this session is to focus on the progress on the site since June 2024, the contract with the development funders and the development project plan, and compliance with and delivery of the master plan. An agenda was issued for this last week, so hopefully you've all got that. I guess for the benefit, one of the live broadcast, and also for Mr. Cunningham's benefit, it would be helpful if the lead participant for each party introduce yourselves, just so he knows who's on the call. It's quite difficult, you've got little boxes. So we'll do the appellants team, but I'm sure you probably know them anyway. So who wants to go first for the appellant to introduce yourselves?
I'll go first. Steve McGavin, so I'm from WSP and I'm providing the planning and development support to the appellant as part of this appeal.
Katie Pearson, I'm a senior planner at WSP and I'm assisting Steve with the planning.
Gary Freckleton, a partner at PIP Asset Management.
In London Boardroom, we have Martin Williams and Steve Shakespeare, Development Directors with Arrow Global.
Yeah, and I'm Adam Cunningham, Managing Director of our Arrow Credit Opportunities #2 fund, also from Arrow Global. Would you like any background on Arrow, or did you cover that already this morning?
We haven't covered it, but it may come up on the questions, so you can do in response to the question. It's up to you when you want to introduce that.
Sure.
I'm assuming from my list that clearly Ian Struthers and Martin Nichols aren't taking part because they were dealing with flood issues. And as Vice Watson on here, so she's on here but taking notes, which is absolutely fine. Okay, Mr. Nelson, for the council, can you introduce the team you've got with you?
Good afternoon. So, Mr. Nelson, this is Mr. Nelson. I'm solicitor for the council. To my left, we have Leslie Carris, planning team manager. And then after her, we have Christopher Sillick, who's planning officer. And closest to you is Kenny Bowes, who's the senior planner.
Sorry, I didn't introduce myself again, but I'm Charles Price. I'm the managing partner at PIP Asset Management, carrying out management work on the estate for the appellant.
Thank you, Mr. Nelson. I'm again assuming that Gordon McNamish and Thomas Finlay aren't taking part because obviously they did the flood stuff this morning.
That's correct. They're with flooding issues. Yeah.
Okay. And Elaine and Naomi will take part tomorrow in session 3.
That's correct.
Yeah. Okay. Thank you. Okay, great. So just some housekeeping for Mr. Cunningham's benefit. When you're not speaking, it's something quite useful just put your microphone off in case there's any feedback or background noise. Phones and other devices must not be audible during the session, but if you need to get in touch with your colleagues in different rooms, that's absolutely fine. If you need a German at any point to discuss a response from the appellant's perspective, giving you all different names, that's absolutely fine too. We can do that. Depending how we get on this afternoon, how much progress we make, we may have a short break during the session, but I'm fairly confident we'll get this session done by close today. So if you've not been involved in the hearing session that we do with the GPA, it's a structured discussion between the parties, chaired and guided by me. The purpose of it is to allow those taking part to put forward your views, and at the same time allow me to obtain the information I need to determine the appeal. The discussion should focus on the items identified in the agenda. You can ask relevant questions through me, and we can have parties respond to those. I do take notes as we go through. It is recorded, so I can obviously watch it back, but it's useful for me for thinking to take the notes and pointers to them when writing the decision up later on. Does either party have any procedural matters or questions they want to raise? So for the appellant, does anyone have any questions at this point or procedural matters that you want to raise? No, lots of shaking heads. Okay, and Mr. Nelson for the council, do you have any procedural matters?
No, ma'am.
No, okay, great. So I've pulled up the phasing plan that was sent last week for the appellant. I've also got a few other documents which we might touch on, I'm just not sure. Are there any specific documents anyone else wants me to get to hand now, which you might refer to as you go through this afternoon session? This doesn't preclude you referring to any document that I've got in the case file. It's just so it's easy for me to look at and I can pull them up now on my screen. But if there's anything particular that you want me to look at, you can let me know. There may not be, so it's not a trick question. The appellant, no. I've got the phasing plan. There may be others, but that's maybe the key one. Mr. Nelson?
No, ma'am, I think it's just the plans and should everything's in.
Okay, that's great. Okay, so we'll start off with question A, and we'll work through the agenda. As we found this morning, sometimes we stray into other questions as we go through, which is absolutely fine if it's more appropriate to deal with it at that point in time. And I can take stock as we go through and make sure we've covered everything to my satisfaction, because I also need the evidence to make the decision. So the first question was, really, I'm looking for an explanation of what works have been undertaken since June 2024, which is when the last decision was issued, which was then quashed. And it's useful if you could do it with reference to the plots in the master plan, just because that's easy to then visualise what's been happening, and we can all see the master plan. So I'll open that up to the appellant, whoever wants to start on that one.
I can kick off from our perspective. I mean, so since June 2024, I would say the work from our perspective consists of site and site prep work on the sites on the plan known as 29, 35, 8A and 8B, the Marina and Middle Pier Boatyard, 9A and 9B, and 7B and 8C. And then also the reclamation of part of plot 35A, or actually most of part 35A, which comprises around roughly 4 acres. And then followed by the completion of a temporary inner harbour revetment wall to the western harbour. Those are the main things on site, I would say, that's happened in the past year.
Sorry, I'm on mute. Can you just go through those plot numbers again for the site prep works?
Sure. 29, 35, 8A and 8B, 9A and 9B, 7B, 8C, and then followed by the reclamation of work done on plot 35A.
So was this a lot of like infilling work, say site prep work? Because when I went on site, so I'm trying to think when I went on site, it would be the start earlier this year, and it didn't look like much had been ongoing at that point in time. All the areas were kind of grassed over. There was nothing, no visible groundworks. When I was out.
What stage was that at, sorry? What point in the year?
I can just confirm that for you. Give me 2 seconds.
But the team can sort of chime in, but essentially, as I understand it, it was a lot of the infill for the plot 35 came from the preparatory works that were done on the surrounding sites that I just listed, and therefore, smoothing those off and flattening them and moving that earth essentially was the works undertaken.
Okay, so I was there in March. So start March, I was on site.
Yes, a lot of it was done well in advance of March.
Okay.
Sorry, Charles, go on. Do you want to add anything to that?
If I could assist, the Inner Harbour revetment wall construction was completed in December 2024. And by the time I think you carried out your inspection, most of those works had been done. There were some interim works, but they were relatively minor in relationship to the amount of work that had been done through the latter half of 2024 was when the main work was done.
Okay, as you're saying, the infill was taken out of these plots, so that would have been done to allow you to finish the work. So it'd been that was an early start in that piece of work. So they might have well been grassed over by the time it came to March.
100%. Yeah, sorry that if I wasn't being clear, that's what I was trying to say. I'm not surprised that was the case because most of the cut part of that would have been early last summer.
Yeah,
or late last summer, potentially.
Okay, Councillor, have you got anything you want to add or comment on for that?
Nothing extensive at this stage, because I think much like yourself, I haven't been to a lot of these plots recently. I would just confirm that we've submitted our views on the sites and the progress in written submissions already, and would probably agree with your initial observations that there's relatively little evidence of progress on those sites that have been highlighted.
Yeah, no, I've got your written submissions, so yeah, obviously they all get taken into account as well. But that was my initial view, that there was very little evidence of any progress, but understanding the works that you were doing, that probably explains why it wasn't very obvious when I was out in site. Okay. Mr. McGavin, do you want to come in?
Just to follow up on that question, can I just ask when the council were last out on site to inspect progress?
So I visited the site with my colleague Kenny Bowes in December, but again that was to plot 35A. It wasn't to the wider site. I've been to elements of the wider site probably twice over the last. I'd say it was around about the time of the last decision to look at plots around FUT, KPQ, and that kind of area there. I couldn't tell you when I've last seen it. No, in the summer I've seen plots 9, A and B. So I have seen elements of the site, but again, not recently, because the vast majority of those plots are fenced off.
Mr. Gavin, do you have any follow-up point you want to make to that? No, you just want to clarify. Okay. Okay, if we go into question B, just want to know, are there any works currently ongoing or committed, for example, or any contracts in place currently for any works?
Yes, so the work ongoing at the moment is more around the preparation, submission and responding to the various consultation requests around the new planning application reference. The reference number for that, sorry, for the record, is 24/03097/FUL, which relates to plot 35A. Noting from my perspective, that this application has still not been determined after over 14 months as well. So that's the main thing. I would say also in March 25, we, or the appellant, ordered works for the detail engineering design for the Western Harbour inner revetment wall and the revised marina licenses, and for which the work is nearing completion, but noting that a time extension has been requested by Marine Scotland because one of the statutory consultees, namely CEC, has failed to respond by their original deadline of 8th of June.
But there's no ongoing construction works at this point in time.
At the moment, we feel like we need resolution to these matters before we can continue those construction works. And it's an integrated project we've got here.
And I guess for the same reason you haven't committed by entering into any contracts for any future construction works.
I'm going to pick that up, Adam.
You go for it, Martin, if you want to.
Yeah, so I think it's important to understand that the evolution of bringing a master plan through for delivery. So you have your master plan design, you have to go through final design workshops, you have to go through checks for building regulation compliance, you have to make sure that a scheme that was consented many years ago can be delivered to current build regulation compliance. So there's an awful amount of work that's been ongoing in the background with third-party professional advisors. As Adam and Charles have said, waiting for the determination on 35A, which is actually quite a critical piece of the development because it's going to bring back to life the sort of waterfront. Until you've got that piece of work finalised and you have a determination on that, you can't go to detailed tender. Until you've been to detailed tender, you can't instruct contracts. So there's a massive amount of work that's ongoing in the background, but we've been held up by the statutory authorities who have failed to make a decision. So everything hinges off that decision-making process.
Agree. We couldn't be. Thanks, Martin. We couldn't be more keen to get going on as many sites as possible. We've got the capital. This is now owned by our ACO2 fund, which I mentioned, which is significant capital that we could deploy immediately if all of these issues were resolved to get this moving in the manner Martin said. But we need everything resolved around this before we can start.
Just out of interest, why did you pursue plot 35A through a new planning application?
Maybe I could answer that. Because of the timescales involved, it had to be a new application because of the expiration of the planning permission in principle. And we were trying to understand what the reasons were for the council basically intent, as we could see, to on refusal. So the best way of dealing with this was to draw out everything that they wanted to say, and having said it, we could then address it. And I think from you heard from this morning's hearing, that's no mean task when you're dealing with CEC, flood, and SEPA, to actually get to the finality of what it is that people are expecting and want to provide. And that's the reason for it. It's a practical reason. It had been refused, and therefore we had the ability to make a further application without paying yet a further fee, because a full fee had been paid. That's where we're at. And I want to reiterate what Adam has just said, and indeed Martin. This is a master plan. It's by very nature, it's very complex. It consists of a number of different uses on a number of adjacent plots. And if you think about the practicality, 35A is immediately adjacent to plot 35. And you've heard this morning, and you'll hear further, about the necessity to ensure that there's nothing that happens on 35A that affects 35, inundation, flood risk, etc., and vice versa. And it's one of these developments where it's kind of difficult to imagine that you would have two sets of contractors trying to carry out two quite large developments next to each other at different times, when one actually is really connected to the other by roads and infrastructure. And I just reiterate that Adam's point that basically these matters need to be resolved as soon as possible, because the appellant is anxious to get on with the development, has the whereabouts and the ability to get on with it. The only hiatus I would point out was the time that was taken. I think Adam will agree, the due diligence on the deal that was done, which we had to struggle with. Adam and I met to agree with the clients this deal in June of 2024, but it took 9 months to get to the bottom of this, and for Arrow to understand the complexities of the planning, which you, Madam, are beginning to see in great detail. So you can imagine third party coming into this want to be satisfied that their due diligence was properly carried out, and it involved a tremendous body of work. And that's another reason why there's been some hiatus for a few months on the site. But immediately the matter was concluded, I received very swift instructions to get on and order the preparation works, because these works are required to build the marina. You can't build the marina without the inner harbour revetment wall and the North Mole extension, and satisfy the licenses of Marine Scotland. So we're very much under statutory controls here. And that work is time consuming, but was started right away. I think we're getting close to the end of it. I think that basically within the next 4 to 6 weeks, we should have sufficient information and responses, and that will then enable discussions then to take place with who's going to deliver the development. But to do that on its own without certainty on 35A, and therefore the knock on to 35, is the issue, because these forms of construction are immediately adjacent. I mean, the inner harbour revetment wall is right next to plot 35A. And you've heard with great conviction from CEC and SEPA this morning their concerns about what the effect on adjacent sites are. Well, yes, and in practical terms, we have to be concerned about it, because we need to know what we're doing. The client can't just write a blank check for a specification that's unknown. That's not going to work. That's why we want this certainty of getting on with it, and as quickly as possible. Thank you.
Can I just clarify? I know you said the roads are in, the roads surrounding like 35, 30 in that area are all constructed under a different plan permission.
Yes.
Are the various plots serviced, or are they not serviced, but services can be taken from services in the road infrastructure?
Correct. The services are privately owned: drainage, sewage, lighting, roads, pavements, cycleways. They are next to these sites. So if you see on the plan, you can, I think when you went there, you could see that probably you walked on part of the road, then it would stop at the bell mouth to the sites. And it's there that you create the connections. So we're in quite a unique position that we can swiftly deliver those infrastructure items which so often hold up developments, but particularly when you're dealing with statutory authorities like Business Stream in Scotland or Thames Water down here. So we're quite lucky that we are in control of that. So that is something which is easily attainable, easily deliverable. So your microphone's off.
Sorry, with that in mind, just trying to think, it wouldn't be totally unrealistic to have two contractors on different plots at different times. Sorry, at the same time.
I'm talking about the adjacent plots. I'm talking about the subject of the subject matter here, which is really how 35A impacts and with the Inner Harbour revetment wall and the immediately adjacent site, which is 35. You can have other contractors on other sites.
Okay.
You're quite right.
Okay, I'll ask the council if they've got any comments at this stage.
Thank you, Ma'am. I suppose our first comment would be that in terms of 35A, our position on 35A would be that the full planning application is required because it's not covered in its entirety by the outline planning permission as part of this appeal. So when the first application would have come in, for example, that would have been in 2021 06413 FUL. Again, that was submitted as a full planning application because elements of the site fall out with the boundary of the outline planning permission. And in terms of, I understand that this is just probably for clarity for us. I understand that we've had that discussion there about 35A and its pending consideration, and I can understand why work needs to be done in terms of that. But in terms of the wider plots, you know, kind of plots like 7B and 8C and 9A and 9B, if the appellant's position is that those are outstanding permissions, I don't see what the delay would be in progressing those sites. We haven't really had any discussion in relation to that. So I suppose the council doesn't understand why there hasn't been progress there. And again, just to note that whilst elements of the site might have been harvested for infill materials to support 35A, I wouldn't necessarily view that as being linked to the commencement of those consents. So again, it would be a question of what work has occurred on the sites. I suppose we leave it there for now.
I mean, to take it in reverse order, I mean, I agree that the fact that infill was used for 35A doesn't necessarily mean there's progress on site. I think it was more saying that was evidence that groundworks had occurred. Flattening and preparing the sites at the correct level to start development works is the work that was undertaken on those sites. I mean, to address the first point, again, as we've said, this is a master plan and a scheme that needs to be economically delivered. It's a very different prospect to build and sell a set of apartments that look over a marina, a properly constructed marina revetment wall, etc. Then one where that's no longer possible because of planning constraints and other issues. So the development needs to hang together as one economically, as a proposition before we can move forward with it. I would say so that's what we mean when we say this thing has to be delivered as an integrated master plan. I don't know if the team want to add to that.
I think the other important factor there, Adam, is that what we're trying to achieve with regards to the overall delivery of the scheme is, we want to create a place where people want to live, where they want to have businesses, where you want to encourage visitors. If we just started by putting up blocks of apartments ad hoc, you're not going to get that placemaking effect. And the whole concept of a regeneration project is that you breathe life back into an area that has previously been disadvantaged by its industrial past. And at the moment, we want to enhance that placemaking, and 35A is key to that placemaking piece. So it does all hang together. And then you have the second element, which is your construction phasing plan. And to optimise efficiency with contractors, the flow of materials in and out of site, you have to have the final scheme known to you so that you can create your phasing plan. We have a team of professionals that are ready to go, and who will make that optimised plan for us, so that when we start delivering, we're not there for 5-6 years coming in and out. It goes through a process, and we come to a conclusion where we have a very good and very economic scheme. And that is the purpose, or that's the ethos with which we're trying to look at this project. We're not here to just put up 1 or 2 blocks and then come back 3 years later. When we start the construction, we're going to take this through to completion.
I guess, and CEC, we asked a question, why has that not happened before the PPP expired?
Sorry, was that a question for
Was that a
ourselves?
question for us or the council?
A question for the appellants. Bear in mind that this is the second extension you're seeking. So you got the first one, I think, in 2019, 2020. So we're looking at a second extension. The original PPP was for 15 years. Why are we at the point again where an extension is being sought?
I mean, for us, as Arrow, we can't speak to the past as to why it hasn't moved forward. We've acquired this site it was early this year, Charles, or late last year.
Yeah.
It was in the last 6 months we've acquired this site. We have ample capital to progress it. The way our business works is we like to get things done as quickly as possible. So I can't speak to the past, but on behalf of Arrow and ownership of this site and taking it forward, we've done everything we can, we think, to get things lined up as fast as possible. As Martin said, we'd spent a lot of time engaging with a panel of specialists in the background ready to go as soon as these decisions and these matters are concluded. I don't think we could have done much more since we've come in.
I would just reiterate that and go further. I'm interesting to hear from Mr. Sillick that not aware of what works were trying to be carried out. I mentioned before that the sewage system, it's a privately owned sewage pumping system. Sewage pumping systems are quite commonplace in this type of location. So the sewage is pumped down to the main road and then joins the main structure. The sewage pumps need replacing. They are probably 20-something years old in terms of specification. There's newer, better, more efficient ones. But the regulations have changed so that for these to be adopted by Scottish Water, it means that certain changes have to be made, not to the block of 9A, 9B, but just to its location, because they want a certain distance between the sewage pumping house and the block. We suggested to, and actually wrote formally to CEC last year saying exactly that and asking them to deal with it as a non-material matter, which they could have done within their discretion, but decided, no, we want a new application. A new application starting afresh without the time extension would be, apart from being costly, it would take a lot of time, whereas an AMC application can be dealt with very swiftly. And so there's a tangible example of the issues that maybe answer your question. Why is a time extension required? Why is it taking all this time? I don't know. I've never seen anything quite like it. I mean, on the previous consents, which have been referred to earlier, what were there? There were 5 applications, 4 refused and 4 won on appeal. I mean, it's just been an extraordinary uphill struggle for a scheme that everybody goes, this is what's required for this area to regenerate. It's a rather more privately focused version of what the council are doing for their own waterfront scheme, which is just up the road. So I don't understand what the issues are all about, and I really don't understand why it has been such a constant struggle. You'd expect this to be taken forward on the basis of delivery as quickly as possible, and that's why the appeal, allowing this appeal, will enable matters to be expedited. Where AMC applications like 9A, 9B, just to get the sewage pumping system up to scratch, will save a lot of time. And by the way, reiterating what Adam has said and Martin, that sewage pumping system affects all the blocks. It's not just the one block. It's located there, but it serves the whole development site. So it's a rather integral part. It's an example of how a master plan is an interconnected being, and therefore you need to have all resolved. It's also a cost implication, because basically you had to relocate the whole thing. I think the current estimate, last estimate I gave to Adam was about $500,000. I think with inflation it's probably about 600,000. And if you actually moved the block, the actual cost would be somewhere around about 200,000. It would save a lot of materials. It would be a better carbon footprint, obviously, because you wouldn't be using so much new concrete stuff that is required. So I give you a tangible example of what has gone on. I can't explain the delays. I still can't explain them. I can't see that there's any excuse whatsoever for these matters not to be dealt with, especially since the planning officers in their own report go, oh, what a great scheme, we love the development, we love this, but don't seem to love it enough to let it go ahead, which is the issue.
I'll let CEC respond to that, or those comments generally.
Thanks very much, Ma'am. I suppose I'll try and go through that step by step. There was a lot there. I suppose first, in terms of Mr. Price's comments about plot 9A and plot 9B, I've set out a view on this in previous written submissions, but is it going to be useful for me to address that now? I mean, I can do. It wasn't myself who dealt with that. It was my colleague Ken Bowes, and I suppose he could fill you in with the detail. But my understanding is that the changes for that particular plot didn't just relate to the sewage pumps. And I'll let Kenny perhaps come in on that just now.
Yeah, I'm not entirely sure how relevant this is to this appeal, but certainly 9A9B, the non-material variation that was submitted was a significant design change, and so it couldn't be taken forward as a non-material variation. It kind of moved the building, it redesigned one corner of it, it infilled various parts which were open, and it just wasn't something that we could progress as a non-material variation.
And I suppose then we come to, do you need to have an outline planning consent to address that problem? And would it be any quicker to deal with an AMC application rather than a full application for that site? And our position would be that both would need to be compliant with the development plan, with the only kind of caveat being that obviously for an AMC application you're to a degree limited by what the reserve matters are and what the conditions are in the outline consent. But again, we'd still be assessing each application in terms of compliance with the development plan and expecting that to be justified and to comply with the development plan unless material considerations set out otherwise in line with section 25. And I suppose just in general, just to be completely clear on what we're talking about today, because I think we keep on falling into the trap about talking about the master plan and delivery of the master plan, and I can see obviously it's very important, but this appeal relates to a planning permission in principle. What we're here to talk about is the planning permission in principle and whether that should be granted in relation to this whole site and not just these plots. But it's quite different to the master plan. I understand that the master plan exists, but we've had various master plans relating to the site over the years, which have been amended in line with what the appellants come forward to us with, be it guided by market forces or whatever. But we've had a series of master plans. We've had the most recent master plan being 17-0248 for PMC, which still is in place today, subject to the conditions that are there, again relating to plot 35 and relating to some of the plots where we haven't agreed. But again, I just don't think that those two things should be conflated, the planning permission principle and the master plan.
Any response from appellants?
I guess the only thing is that I guess the use of the word master plan is less in the technical sense of a particular document, more the fact that this is a combined plan, I guess, and a combined scheme for us. Less in the technical sense of the word.
Okay, I'll move on from there. So I think it was in the written submissions in response to the procedure notice that the appellant advised that I think it was in March that they had entered into a funding agreement, which was with Arrow. But in correspondence this week, there was a suggestion that there was no contract because the funders are the owners. So I just want to clarify, what is the situation? Because I'm just not very clear what that situation is anymore.
Yeah, I mean, fairly simply, we were originally funders, but we took ownership. We have now taken ownership of the site. That's simply it.
So Arrow Capital are now the owners of the site?
One of our funds, Arrow Credit Opportunities 2. Yes, they're the owners of the site. All of the plots listed here. Previously having been the senior secured lender against all of the same.
Okay, so you've acquired it from Edinburgh Marine Limited?
We acquired the entity Edinburgh Marina Limited in its whole, its entirety, I believe. The share capital of.
Okay, so you acquired the company?
We acquired the company,
okay.
So. Yeah.
Okay, that makes more sense. I'm going to ask a question, and you may not want to answer because it might be commercially sensitive, which is absolutely fine. Prior to you acquiring the company, was there a funder on board for this development?
I guess we were the funder prior to us acquiring.
And when did you become involved?
We initially provided acquisition financing. Let me just think it was late 22.
Yes, it was. It was. If I can help you, it was in 2022.
September
the funding took place. Yeah, September 22, and the acquisition of EML took place on was completed on March the 18th this year.
But we've also we funded the works that have taken place on site. We're funding the works for the that we were discussing this morning, the wave modelling, all of the third party costs. We've Arrow just carried on funding those. So it's not that we funded in 2022 and stopped. We've had an ongoing commitment to fund the works in progress.
Yeah, correct. We did an acquisition facility and then subsequent facilities to fund the works that we described. And then
you've now acquired the company. Okay.
Acquired the company.
Yep. Mr. Nelson.
Just for clarity, so are we saying that Arrow now own the areas in blue from the ownership plan that was shown as EML, and the rest of the site is not owned by them in terms of the application?
My understanding from what was just said was that Arrow have acquired the company EML, so the actual land ownership doesn't change, just they own that company, is my understanding. But it was
We
only,
own in control. Yeah, sorry.
yeah. So a title disposition, the title and land register would still be in EML, but that company is now owned by Arrow.
Yes, I think
yes.
Was that
was what I understanding. We were just clarifying was the plan that we're then showing that was shared last night by the appellants then shows what the EML land ownership actually is on this relatively small portion of the site that relates to.
Correct. That is the up-to-date title plan of ownership requested by the reporter.
So only the land that's shaded in blue is land that you have control over. Is that correct? Yes. Is it? Is that correct? Only the land in blue you have control over.
Give them chances to look at the plan.
I'm just getting up 1 second. For some reason, the shading's not working on my machine, but it's the plots that we've discussed earlier.
Yeah, so on the plan,
it's all the plot numbers.
So yeah, my plan comes up as plot 35, 35A, plots 8A, 8B, plots 7B and 8C, plots 9A and 9B. You've got plot R, middle pier.
Yep, and then the pilot station. And then a couple of little strips.
So yeah, little thin strips, and then you've got obviously the seawalls.
Okay, thank you. And do you mind if I come in with a second, just in terms of the green, the roads, that's not owned, or you don't have control over the roads? Is that the case?
The green land, Charles, is the GHL owned land.
Yes, if I could assist, the GHL land is in fact owned, as I say, by GHL, and Arrow does have an interest in it insofar as they are lenders to the company, and in confidence it's likely that they will take that over at some stage so that they will own it. But you will note that it is a connected party in that regard, and we made that clear. And we made it clear in the plan that there's no connection with any of the third party owners who have been identified on the plan, because they are completely separate to any of us. There's no connection whatsoever, except they're actually on the estate. I think that's been identified.
Agreed. I mean, to sum it up, we're senior secured lender into GHL as well. And as Charles said, our very much intention quite shortly is to acquire control of those elements as well directly, similar to what we did with the plots we just discussed.
Okay, and when you look at the phasing plan, there's the phase 3, which is shaded pink, which is, if you've got that, which is at the plot 22 or part 22, kind of goes in a little bit 23A, 21, parts 21A, 20, sorry, bit of 20B, I believe 19B, but none of that is shown on the ownership plan.
Well, the numbers are different. It's one of those things that we inherited. I think the council agreed. So kind of confusing. There was one set of numbering, then another set of numbering, but the colouring is correct, and a lot of those commercial properties are subject to long ground leases as well. So they were always going to be the deferred part of the scheme. When the master plan was even first came into being, there was always going to be a delay factor because these properties are occupied by commercial enterprises and have some of them have quite substantial businesses. But eventually they will be developed and will be delivered under the master plan by these individual owners. We don't have obviously transparency as to when their plans will take place, but it's pretty obvious that as the development proceeds, that's what they would do. Some are owner occupiers, by the way. Some, not all are subject to leases, but some are owner occupiers, and where they're owner occupiers, they'll be the first to get on with it.
But the area shaded pink on the phasing plan, you're not in control of that area.
We have no interest in that area. So I'm sorry, I now see the shaded piece. So blue and green essentially are the areas we're in control of. We discussed the roads as well just now, but not the pink. We have no interest in the pink.
So when that's highlighted on the phasing plan as phase 3, that's relying on third parties to deliver that.
Correct.
And then, and this is kind of touching on question D, sorry, in the agenda, if you're wondering, the other plots that we have at the bottom, so you kind of got plots 11, 12, 16, 14, 15, 15A, that area, is the intention for that still to be developed?
11, 12, 15A, etc. Is that the question?
Yeah, on the phasing plan. So at the southern corner, there's plot 17, 15A, 15, 14.
Oh, I see. Yeah.
Yeah, it's not shaded at all.
We can't speak to that. As to what the plans are. I don't know, Charles, if you're aware of what's happening on those, but from our perspective, it's not within our perimeter. You're on mute, Charles, if you're speaking.
I think I just ask Gary, I think could assist here, because you've got the plan up and I don't have it handy because I've got too many machines running, but the properties that the reporter is asking about, the ones that she's referring to in the southwestern corner, if they're not owned, then it's not something that we can deal with. Is that right?
Yeah, that's right, because I believe it's, the KOPQ.
Yes.
That corner. Yeah.
Yeah. And there is a commercial tenant in one of them who's got a long lease of 45 years. So that's why it's in that sort of last phasing. But they will get developed. I think I'm fairly certain that they will get developed, subject to market conditions and.
Right, the area I'm speaking about isn't shown on phasing at all. It's
sorry, Gary, can you help?
It's a bit when you first.
Could you screen share?
The southeast corner they're referring to, but I mean I think the comment stands, right. They're not owned or controlled by us. We can't comment on the sales.
Okay, council, got any comments?
I suppose it's just to clarify then, or for it to be completely clear, that where those areas are shaded, no one from the appellant side has any control of that area of land, so it's not possible then for us to sit here today and say that the master plan will be delivered out as a result of this permission. That'd be fair, because it's not that it won't be delivered out, but it's that it wouldn't be delivered out by the appellant, who has no control over the bottom half of the site.
I mean, like, I think that's fair to an extent. We'd say the more material aspects of the site in terms of land area and high value delivery are within our control, would sit at the front. But yes, those small sites and indeed the ones which currently are under commercial use aren't directly within our control.
It is interesting is that the sites that are in third party ownership, many of them actually have been developed. So it's not correct to say that the master plan isn't being delivered. In fact, it has been delivered to a great extent by others. We've assisted them in that endeavour. Currently, so over 750 homes have been built, and 520, I think, are affordable. So that's not been done by the appellant or any company associated with the appellant. So it's not true, not correct it's incorrect for the council to say that the master plan can't be delivered. A master plan of this type, which the council knew about, sites being sold off right at the outset. First sites were sold off by Fourth Ports, if I've got this right, in 2002 and onwards. They sold many sites, and they were sold for development, some which took place, some which didn't, and then subsequently some have now taken place. So over a period of time, it's not unusual. This is a complex site. This is a multi-ownership site, always has been, and has lots of different leasehold interests. Councils, no surprise to the council, these leaseholds have been going for a long, long time. So they will know about all of the various tenures, or should have known about them. But it's my view that the master plan will, over a period of time, be delivered. It could take another 30, 40 years for the last parts to be done. But the main part, the part that's going to regenerate the area, the marina and around the immediate sites, that's what's going to produce the economic regeneration. And I think, as Martin said before, the placemaking.
Me, Trudy, sorry.
Madam, you're muted. We can't hear you.
Truly on mute, yeah.
Oh, sorry. Always happens at some point in a meeting, doesn't it? I was going to ask, going on to question E in the agenda. We've got the different phases shown on the plan. Have you got any indicative timescales? I know it's subject to planning, other permissions, consents you might need, building regs, all that kind of stuff. But what kind of timeline, indicative timeline, are you working to at this point in time to complete these phases?
I mean, as we sort of covered earlier in the meeting, as soon as we can get conclusion, hopefully a favourable conclusion on the Section 42 application, will greatly assist the delivery of the development master plan from our perspective, our master plan. that will then allow us to finalise the timetable. But as Martin covered, we've got a panel of 3 to 4 different sets of professionals that we've already pre-vetted, that are ready to go and start work almost immediately on this. I mean, it's a matter of public record, but our fund life has around 5 years left to run. We wouldn't like to run it to the end of that fund life. So, we would like to start immediately and have this thing completely built and done well within that time period, which for something of this size will require us to get moving quite quickly. So yes, as soon as possible, the timescales for starting.
Council, anything you want to comment on for that?
No,
nothing further. No.
What happens to the fund at the end of those 5 years, end of the fund life?
We can have, at the consent of the investors, if there's particular things still ongoing, we can have 2 one-year extensions only in specific instances. So if there was still some development to do, or we could sell it to another fund like ourselves who might want to finish something in train. But ideally, we try and avoid that if at all possible, which again is why we're so keen to start immediately.
I think it's worth noting, Adam, that none of the blocks in isolation are, when we're not talking 3 or 4 years to build each block, you're probably looking at 18 to 24 months to actually get the blocks constructed, PC'd and finished and sold. So with the timeline we've got left on the fund, and with a fair wind, we've probably got a mobilisation period of 6 to 9 months with the professional team to finalise the designs, the building reg applications, all of the pre-commencement conditions that will have to be discharged. So you'd hope to be on site within that 9 to 12 month period, actually cutting ground and then into delivery phase. But just to set expectation, there is that sort of pre-commencement process that has to be followed, and we can only do that once we know what consents we're working with.
So really what you're saying is plot 35A is kind of the key to this, separate application with the council. Once you get approval, or otherwise than that, assuming you get approval, that would then unlock you guys just kind of hitting the ground running on everything else within phases 1 and 2.
Yeah.
Try and get that done within your 5-year window.
Yeah, that will trigger the formal appointment of the management team to formalise the pre-commencement applications, the building reg applications, and then the tender with the contractors. The tender process itself will probably take 3 months with contractors. Once you have the finalised designs, the tender process, the refinement. But it's but as Adam said, we have 3 specific firms lined up who we've interviewed, we've vetted, we validated their previous capability and experience of delivery. They're waiting for us to give them a nod, and they have been since the beginning of this year. So we haven't been sat back idly doing nothing. We've prepared as much as we can in the background so that we are ready to go once we have a decision.
Okay, Mr. Nelson, your hand's up, the council.
Thank you, ma'am. It was just to come in on that point, in that slightly confused because all the plots within the applicant's ownership, with the exception of 35A, already has consent for development. So slightly confused as to.
I think where we're coming from is regard setting aside our queries about whether the degree to which any of them would be commenced in terms of plots, A, 8B, 7B, 8C, 9A, 9B. I take on board what the appellant has said about, it seems, the importance of 35A in delivering the rest of the development. But I would just observe that this appeal relates to a planning permission in principle. 35A is a full planning application that isn't covered by the planning permission in principle. So regardless of any decision in relation to this appeal, it doesn't affect 35A. 35A is subject to a full planning application, which is already submitted and pending consideration.
With respect, it feeds into the construction phasing plan and how the whole scheme stitches together. So, no developer in their right mind is going to start building on a site until they know exactly how the phasing is going to work, and how the process flow through the estate will work. You don't want to be building blocks of apartments on the back part of the site to then be pushing trucks through for the next 2-3 years and upsetting all the residents who have moved in to service plot 35A, which is at the far end of the site. There's a logic to how you go about construction and development.
And I get that from a construction perspective. I think what the council are getting at is that, and it's my next question actually on the agenda. As far as I was aware, looking at all the information I've got, it looks as though AMSCs and notice of intention to develop have all been issued for all the plots that you've got an interest in and will be building out. So I was asking, what further applications do you think you require that would necessitate the outline plan permission to be extended?
Well, I think I'd like to answer that. As I said before, the sewage pumping system is privately owned and needs to be upgraded, replaced, and then adopted. This sewage system serves all the sites that we're talking about. And therefore, notwithstanding the comments made by Mr. Bowes, we need to move the block so that we can accommodate the requirements of the statutory authorities for the adoption of the sewage pumping works. As things currently stand, the appellant will be forced to make a new full planning application. If, however, the appeal is allowed, then they could make an AMC application. And they could conceivably, if they're going to continue to be delayed in respect of 35A, they could at that stage put in an AMC application on 35A. Because at this moment in time, and perhaps the council would like to give some comment as to when they feel they're actually going to progress 35A to take it to planning. Last thing we heard, they want yet another pre-application consultation for a scheme that's identical to they've already had a consultation. We've got no dates. We've got no dates. We've got no dates. We've got no input at all. We get no response.
It's a predetermination hearing, Mr. Price, that we're required to do under NPA4 and the legislation.
Well, why didn't you get on with it? Why didn't you call it? Why didn't you get on with it? We've asked you. If you want to, if you think that's necessary, you had one last time. So if you want to do it again, do it again. I mean, all it is just taking longer and longer and longer.
The process on plot 35A is not before me. It's not a matter of my consideration.
Right.
So we're not discussing that plot specifically today. You guys can fight about that at some other time. What I'm trying to establish is, given that I think it was document 11 that was submitted, which listed all the applications that you'd submitted and granted to date, the notice of intention development that you'd submitted, what is it that you would still need under this outline or plan permission in principle that you don't have at the moment? Granted, 9A, 9B, I totally understand where you're coming from there as an AMSC.
Well, 9A, sorry, madam, 9A and 9B, that is a very important aspect, because basically that's the sewage system that drives the whole estate, not just our clients' properties, but the appellant's properties, but it also services third-party properties. So it has to be done, and that's why this is being pursued. I know nobody wants to talk about 35A, but on the other hand, it is an integral part of the master plan, and it could be dealt with under AMC. In fact, it would be dealt with under AMC, because you just heard, oh well, let's go and have another consultation meeting. They had one last time around. It's for the same scheme, so it's just going to delay matters interminably.
I think the point was that not all of it falls within the master plan boundary, therefore it cannot be part of an AMSE.
The bit that does could.
Have your previous AMSE applications lapsed?
No.
And is that on the basis that you've done this land groundwork levelling of the sites?
A substantial amount of work has been done on all sites, yes.
And when you say substantial, that's the groundworks that Mr. Cunningham mentioned at the start of the hearing.
Yeah, it's a very large amount of earth that's been removed, and the sites have generally been taken down to within, I think Gary Freckle will tell me, about half a metre of the level required to commence construction. You never take it right the way down until the detail's done, but very close to. That saved a large amount of stuff to be taken off site, which would be very cost prohibitive. Its credentials make it easier that we're not wasting earth, and it speeds up the development that Martin was talking about from the point of view of delivery. So, you know, it's a very important part of it. But I reiterate that one of the most important parts of this is we've got to have a sewage system that complies. It doesn't necessarily have to be adopted on day one, but we would be foolhardy to put in new pumps and apparatus in a manner that it would not be capable of being adopted when the block was developed. That was the point. And it has to be addressed. It's an integral part. And one of the things I want to go back to on 35A, not wishing to open up the discussion, but this morning you heard in great detail from the council's flood officers and from SEPA about how they were questioning the site, the inundation on the site. So this inundation, this detail on 35A has to be dealt with, because that's what the council and SEPA are saying. We are very concerned that we know what the inundation effect will be from the development of site 35A. And that means that there might have to be some measures taken on some of the other sites. Well, you won't know that until it's been determined. So that's a very tangible example of why it is important that 35A application is determined, or alternatively, an AMC application can be made on that part of the site, which is the majority of it, by the way, inside the red line. There's only a tiny bit which is used as a common parts area, also in our client's ownership, but that could be dealt with in that manner. So at the end of the day, this is it's all connected, and it's for that reason that we believe that it should be looked at on the basis that this time extension should be granted to enable the client to put their pedal to the metal, or get on with it.
But to go back to my question, other than 9A and 9B, do you need any AMSC approvals for any other plots that are in your control?
We don't know until we go through the design detail, which Martin has referred to. That it may be a requirement. We don't know. We will not know until we get into that level of detail. We would hope that any changes would be of a non-material nature.
Okay, the council, do you have any comments?
Sorry, Mark, could we just clarify comments? Are we talking comments on what was just said, or are we talking comments in relation to one of these specific matters?
Comments related to what was said, which was really item F on the agenda.
Okay, so in terms of what other AMSC applications are required, I suppose in terms of looking at not just because the practical consequence of this appeal being allowed and planning permission being granted is planning permission principle for the whole 33 hectare site. And looking at the whole master plan. So are there further AMSC applications that will be required to deliver at the whole site? Yes. So we'd say that plots 30 and 31, no development has been undertaken there and the consents have lapsed. Again, in terms of, sorry, I don't have the master plan in front of me. I'll try and use the master plan references rather than the.
Wait, it's not 26 was part of the application permission for 27 as well, so it's still a live permission.
Oh yeah, so yes, absolutely. I haven't mentioned 26. 26 would still be still has an extant planning permission. 32, but obviously there is the application that's been submitted subsequently in 2023 for 155 units. That's undetermined due to flood risk issues. But in terms of wider consents, there's the application that relates to KOPQUT, so that is plots 21, 28, 23A, and plots F again. So we do have a notice of initiation for development there, but I've been to that site twice in the last year and would say that there's no evidence of any development there, and so would consider that lapsed and requiring further planning permission. And from what the appellant said to us today, it's not within their ownership or gift to deliver that. The same with plot 19B. We've commented on plots 7B, 8A, 8B, 8C, 9A and 9B. Again, acknowledging that the appellant said that a certain amount of land harvesting, for want of a better word, has been undertaken to provide infill material for plot 35A. I wouldn't say that was linked to commencement for development. We've seen very little evidence of any work in those sites. We haven't had anything since to us which shows that that's been initiated in a way that's specific to those developments. But then the wider site, there are various sites in the existing industrial area which don't have any consents that I'm aware of. So you would be talking plots 11, plot 12, plot 14, plot 15, plot 15A, plot 16 and plot 17 have no planning consents and would require AMSC or full planning applications depending on where the appeal goes. And then in terms of middle pier as well, plot 10, plot 2A and plot W around middle pier have no information on any consents on those plots either. And then as a final
is it fair to say, based on what we've heard today, though, that there would be no AMSC applications coming forward for either any of those plots you referred to within this 3-year extension, given that they're not within the appellant's control and they're all subject to long leases?
No, so well, I don't know what the lease situation is. I mean, certainly for those sites where there are long leases and the current owners have no intention of going anywhere, that might be the case for some of those plots. Then yeah, I would agree that that's the case. Obviously, there might be some instances where developers are looking at some of these sites, and if there is a 3-year extension, may very well submit AMCs. I can't comment on that one way or the other. Outside of the requirement for AMCs, I would also note though that part of the master plan relates to the provision of a new marina, and you know, if you look at conditions for any of the recent master plans, you'll see that as a requirement, as a pre-requirement of any delivery of the marina, there's also the requirement for the North Mole kind of enhancement and extensions. And I would just note that the marina and that North Mole enhancement fall out with the red line boundary of the appeal site, so we'd be requiring full planning applications for those. And then as a final observation, again, the practical kind of consequence of allowing this appeal is the creation of a new planning permission in principle, and notwithstanding any of the permissions that are in place, given that these sites, particularly around kind of 9A, 9B, 7B, all of these kind of areas, I mean, notwithstanding any consents that have gone in the past, the practical consequence would be that, you know, any developer, including the appellant, could come forward with entirely new applications relating to those sites. And so we think it's completely correct that this application, in terms of allowing this appeal only, they already have to be satisfied that it complies with the development plan.
Even if the appeal was granted, there's nothing to prevent someone coming forward with a detailed planning application at any point in time.
Yeah, I'd agree. And I think the kind of example of that in practice is plot 26, where they have an extant planning permission for 132 units, but they've still come in with a planning application for 155. And where we've, you know, found that in terms of addressing the kind of the requirements of the development plan has become problematic. That would be the case for a lot of these plots where, you know, I appreciate maybe some site clearance has happened, site leveling, but I mean, there's nothing tying those plots to any particular development. There's nothing to stop new applications coming in.
So are you taking the view from the council's perspective that those AMSCs, for example, for plots, say 8C, 7B, where there's been that land harvesting, so to speak, are you taking the view from the council's perspective that there has been no commencement of development and the AMSCs have lapsed?
What I would, again, I think as best as I can say is that we haven't seen the evidence of how it's been initiated. What specifically has been done that relates to the consents that were issued, when was it done? And then I would also note, just in terms of, you know, the legal agreement, and it's just a general observation that as a requirement of the legal agreement for the education contributions, I think it's section 3.6. It says that before any commencement of any consent in terms of residential development, that the housing developers should pay an education contribution. And I'm not aware that we've taken any education contributions for those areas. So I would say there's potentially breach there. Although again, whether that, I'm not saying that breach means that they can't be commenced. We've just observed that we haven't had that pre-commencement requirement met.
Mr. Price?
Yes, just picking up on two of the points there. Plot 26, which is owned by Link Housing, seems to be now directly related to the issue of plot 35A, site inundation and indeed flood risk. So the explanation that it's not been determined for that reason impacts upon our application for plot 35A, because it's the same data, and I believe in one of the instances the same consultants, DHI, who are left in the same position that they wouldn't really know what it is that has been required. The other issue, which I think is relevant to what has just been said, concerns the overall development. This is a master plan. The ownerships are fragmented. Many of the sites have been developed. And CEC have just told you, their own words, that they didn't receive notices of intended development, or if they did, they never acknowledged them. All the works that were carried out were logged, photographed, and tabulated and sent to them. And in previous matters, they've agreed that these consents are extant. And then they refer to the contributions required in respect of education. The actual wording is that the sums are to be paid when the developer commences the development of any block of flatted residential units. Have been dealt with by then. And basically, the money seems to be paid upon first occupation. So the works that are being carried out, which are groundworks to implement the consent, don't quite fall into this. The actual words are the sums will be paid as at the date on which the housing developer commences the development of any block of flatted residential units. That's not taken place because in order to do that, you need to have a building warrant, and those building warrant applications need to be made. They can't be made until the appellant knows what they're building. So we all come back to the question of dealing with the outstanding matters. And therefore, there's a very good reason for this appeal to be allowed, to allow this process to proceed to its rightful conclusion.
I'll give the council a chance to respond, and then I might come in some questions depending on the council's response.
Can I, again, it's just off the back of what Mr. Price said. Can I clarify, and I appreciate it's part of a different regime, notifying, but do you have a building warrant for any of the plots? Is it right that you just said that you don't have a building warrant? Because I would have thought that it would be difficult to commence development without a building warrant.
You're able to carry out the groundworks without a building warrant application because you're preparing the ground for the foundation works, which are a part of the building warrant. And indeed, you'd probably have to carry out these works to know what they're going to comprise of, because you know the ground conditions here are a major concern. This is a area of made up ground, and therefore all the developments are going to have to be piled. And in order to do that and to actually have the information, you have to carry out the works. So I would say that we're probably talking off the same page, that the works have been carried out. The development has in itself commenced as a result of what's required. However, the building warrant application, the initial part one would have to be made when the details of the development are known.
So just to come back to the legal agreement, I'm not following your argument, I don't think. It says quite clearly the sums will be paid as at the date on which the housing developer commences the development. So are you saying that you haven't commenced development, or that you have? And if you have, are you intending on paying the contribution? You're on mute, Mr. Price.
Doing what we're all doing now. Maybe I should just leave it open. The housing developer shall be bound to pay the contribution as the housing developer, as determined by multiplying, etc. The the sums will be paid as at the date on which the housing developer commences the development of any block of flatted residential units. That's a physical act. It's normally when the contractor goes on site and commences construction. The works that have been done, these are the preliminary works, but they are works that comply with the definition as basically work commenced. I would ask you to look at your own records, and you've been asked on many occasions, and I don't think the reporter wants to hear me say it, but regrettably, and then I have to say it, you've got all the NIDs, you never responded to them, any of them. And that includes, by the way, NIDs for commercial sites where there's no contribution, or indeed for 9A, 9B, which is a retirement living, and there's no contributions for retirement living. There's no contributions for commercial. There's no contributions for the marina, and there's no contributions for service departments. So we're talking about
Can I just
two
butt
blocks.
in here? I'm just going to butt in here. I think the point that's being made is that you've either commenced the planning permission by doing whatever works you've done, and therefore you're keeping that plan permission alive, or you haven't. Now, if you have commenced that plan permission and you're keeping it alive, under the Section 75 agreement, that would be interpreted as being commencing the development of your flatted development, and therefore a contribution paid. Now, I'm not interested whether you paid the contribution or not. That's not my concern. But I need to get to the nub of, have you triggered the development, therefore your AMSCs are alive? Or are you taking the view that all you've done is some groundwork not related to that specific permission to enable works elsewhere in the site, and therefore that permission hasn't commenced?
The works that have been carried out have been notified to the council, and on the majority of the sites, there are actually no contributions required anyway, because they are not residential flatted developments. So 9A, 9B is retirement. And there was a case actually where the council, from another developer who does retirement living, wanted contributions, and that case was found against the council. Contributions were not required for retirement living over 55 developments.
Okay, I'm not interested in that. I'm just trying to get to the nub of the question.
Yes.
And I'm not. It's not really.
Development has started. Development has started on all these sites. Yes.
I think it's a point of interpretation if it's the same bar between development starting to have implemented the consent, like works that are to enable the construction, and then the bar to trigger the contribution. I think it's a point of interpretation.
And that's fine. That's a different discussion for the council. I'm not interested whether you paid your contribution or not. That's not my remit. I'm just trying to establish if you have commenced development, your position is it has. Yes. Therefore, in your view, the AMSC permissions would be live because you've triggered them.
Yes.
Yeah. Okay, it's 3:30. I'm going to take just a short, maybe let's say 10-minute break. We'll go to 3:45. Give everyone a chance to have 5 minutes away from your screens. We're pretty close to finishing off, I think, but let's just take that time until 3:45, and then we'll reconvene. Then you can just turn your camera and your mic off and then link back into the call. Thank you.
Thank you. Gary, your microphone is still on.
Okay. She'll call me this one.
Somebody still has their mic on.
Yes, Gary.
Okay, welcome back everyone. That's 3:45. Let's let a few more cameras come on. Okay, so just reflecting where we got to, and I think the position we got to was that for the purposes of this appeal, not concerned about the contributions. The appellant's view is that the AMSC applications have been commenced by the works that have been carried out, but you may require new AMSC applications in the future depending on the detailed design for those plots.
Yep.
Okay.
Right.
Having looked at the agenda, I think based on what I now know about the contractual situation, which is an acquisition of the company rather than the contract, I don't think I need to go into G or H. We've kind of covered that with the acquisition and the terms of the fund and lifetime of the fund. I think I has been dealt with. We've covered off the different ownerships and the areas that would be developed out and the areas that are out with the control of the appellant. I think on J as well, I think might worth touching on J if we can get just an agreement on what has been delivered so far in terms of the master plan. So that's something the appellant can just clarify in your view what has been delivered as per the master plan.
I could speak to this point if you want to. So just it's already been discussed in previous points, but just broadly, we've got about 800 homes which have been built out, 520 affordable, as Charles had mentioned, and work commenced on sites which constitute about 320 further homes, hotel, marina. And we also have the infrastructure, of course, which is already built, which we estimate has a value of about 19 million at current prices. So, roads, pavements, cycleways, street lighting, sewage and drainage. We also have the refurbishment of the listed building, the gunpowder store. And I think referring back to the phasing plan, we could basically say that phases 1 and 2 have either been delivered or have been commenced. So I don't know if you want to go through individual plot numbers of which ones have been finished, or are you happy that you know? Because I could just run through a list of plot numbers if it's helpful, but
let's do that. Just then we're all on the same page.
Yeah. So in terms of plots that are finished and delivered, we've got plot 3, plot 4, plots 27 and 28, plots S1 and S2. So those are the residential plots that are already complete. And obviously we have the plots that were shaded blue that the appellant has, which we have the NIDs already submitted and those have commenced. And that would be 9A9B, 7B, 8C, 8A, 8B, 29 and 35. And obviously there are other plots on the site which have NIDs submitted and commenced. So that's plot U, T, plot F, 19B. And yeah, I think they're not in our client, the appellant's control, but they do have NIDs submitted. Is there anything else you want to add in, Charles, that I've missed?
No, I think obviously the old gunpowder store's been renovated and work has started on the Middle Pier boatyard because all that structure had to be reviewed. So they're the other two bits.
In relation to the NIDs for UTF 19B, as far as you're aware, as the appellant, you haven't carried out any works on those plots.
No.
Okay. Mr. Nelson, the council, does that kind of agree with your view of the world?
Yes, ma'am. So I'd like Chris to speak on this, please.
Broadly speaking, in terms of the plots that Mr. Granton has identified, I would agree. Plots 3, 4, 27, 28, S1 and S2. I would also add, just because it falls within the appeal site area, plot 2, although it wasn't brought forward as an AMC, it was brought forward as a full application in 2002. So that's the application reference. I mean, I've submitted it already to the previous report, or it'll be on the DPA website, but it's 02 week 03635 FUL, and that was for 91 units. So the council's view would be that completions today is 890 residential units, including plot 2. And plot 2 also includes 100 square metres of retail space. So we would also say that 100 square metres of retail space have been delivered in terms of contributing towards conditions 16, 17 and 18.
And do you want to express a view on the ones that are stated by the appellant as being commenced?
No, I think we've had that discussion again. I don't think there was a dispute that a certain amount of site clearance work happened on some of those sites that have been referenced in terms of plots KO, PQ, TF. The appellant has just stated here that no works occurred, and that was certainly my observation when I visited the site recently. So I would consider that consent lapse.
Okay. Okay, so I think we're on to the last question, and really,
Sorry, ma'am. Just before we move on from that, I would say just it's not clear. Plot F, plot 19B as well. So again, I'm tying that in with KO, PQ, T. Again, just observing that no work's taking place on that plot.
Yeah, I think Mr. Freckleton did include that in his list. I've got that one noted down as an NID has been submitted, but no work's been carried out by the appellant for that plot. So yeah, that's in the same boat as the other ones. Okay, so the last question was just, I'll put this to the appellant and then get a view from the council. I really just want to hear why new detailed plan applications would be more expensive and take more time than AMC applications, given the conditions that would be proposed and imposed on any planning permission that was granted.
Do you want me to answer that, Charles, to start with? Yeah, I mean, I think just generally that AMC applications we feel would be dealt with more quickly than the new applications, just because of they wouldn't involve consultation and various other factors that you would in a new application.
And the council, do you have a view on that from your perspective?
Yes, ma'am, thank you. I think we'd agree that in terms of pre-application consultation that wouldn't be required for an AMSC application. But in broader terms, in terms of the fee that would be charged for the submission of the application, in terms of the broad assessment that would be required, again, caveating that with it would be tied specifically to the reserve matters, but our view is that it would need to comply with the development plan. I don't think it would be any more arduous or expensive as an ANSC or as a full planning application.
I mean, I think just to respond to the expense part of it, I mean, the fact that I think we all agree that it'll take more time means that ultimately it does cost money in terms of time value of money here, right? As well for a developer and any developer, delays do have a real world impact on the feasibility of a scheme.
Okay, are there any final comments any party wants to make based on what we've discussed today? Any last comments? I'll start with the council. Any last points you want to make? Bear in mind all the evidence we've heard this afternoon.
No, ma'am, we're content to the rest of that.
And the appellant, any final comments you'd like to make?
From my perspective, I'm far from a planning expert, but from my perspective, we acquired the site in March, 13th of March this year. We're really keen to start development and complete this development for the benefit of the area. I think if you visit the site, getting this, at least the part that we're in control of, getting it built out as per what's envisioned in the planning application will significantly enhance this area, I think, of Edinburgh. And this is absolutely crucial in getting this done in a timely manner for us. So we do see it as a key facilitator to getting this moving quickly, which is our desire.
Okay, thank you. So that's, I think we covered everything on the agenda. I know we kind of chopped some of the questions, but I think I've got enough in my mind to be clear on these points. Thank you everyone for your contributions and for taking part either in one or two sessions today. I know it's quite hard work when it's virtual. So tomorrow we will reconvene at 10 o'clock and we'll be looking at planning obligations, financial obligations and conditions. It's a different link for tomorrow, so make sure you click on the right link for joining and to make sure you get into the call. The call will be open again from 9:45 if anyone wants to log on earlier. I imagine we won't go beyond lunchtime. I wouldn't think we'll go beyond lunchtime tomorrow, but we'll see how we go with that. So again, thank you just for your contributions attending today, and I will see you all tomorrow morning at 10.
Thank you.
Thank you, Judy.
Thank you.
Trudy.
Thank you.
Bye.
Thank you.